declare the meeting open to the public. Thank you very much, Liz, for your attendance. Can I advise members that the committee meeting will be recorded and broadcast throughout Parliament buildings and online? Can I advise members and those in the public gallery that they are welcome to use mobile devices as long as they are in airplane mode and all devices are muted? Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rules. It is not permitted to take photographs or record any part of the meeting. Can I advise members that it is proposed that a joint oral evidence session with the PSNI and the Public Prosecution Service on delays in the criminal justice system will be recorded by Hansard, and also the oral session on the Justice Bill. So can I seek members' agreement on this? Agreed? Can I remind members that they are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matter under consideration. Any members who have interest to declare in relation to today's business should do so now or when the particular matter arises. Connie?
Yeah, thank you, Chair. In relation to item 5 with the PPS and the PSNI on delays in the criminal justice system, I think it's appropriate that I declare my fiance was the victim of a crime in 2023. That case is still with the PPS. Okay,
thank you very much, Connie. And I think I'll declare on behalf of the committee members the membership of the All-Party Working Group on the name.
City Justice.
I always forget that.
You should have come and attend a bit more.
Okay, and that's a caveat for the rest, for all of us who would attend that. Okay, agenda item number 3 then is draft minutes. Can I inform members of the draft minutes at the meeting pack on Thursday the 5th of February 2026 at pages 9 to 16 of the meeting of the table pack? Are members, can I ask members, are they content with the minutes or a true reflection of the proceedings of the meeting held on the 5th of February 2026? Agreed? If so, I will sign. Okay. There you go. Agenda item number 4 is matters arising. Can I ask members if there are any matters arising from the minutes that wish to raise? If not, then we will go straight into agenda item number 5, which is delays in the criminal justice system, Police Service of Northern Ireland and Public Prosecution Service joint oral evidence. Can I refer members to pages 316 to 395 of the meeting pack for the relevant papers? Can I remind members, at its meeting on the 20th of November 25, the committee agreed to invite the Lady Chief Justice, the PSNI and the Public Prosecution Service to provide oral evidence to members on delays in the criminal justice system. This was following a briefing by the Permanent Secretary on the Sagini report and correspondence to the committee by the family of one of the victims of the Greenville Hotel tragedy. Can I inform members that providing oral evidence today are Gary MacDonald, Chief Superintendent PSNI, Martin Reid, Superintendent PSNI, Michael Agnew, Deputy Director of the Public Prosecution Service, and Peter Looney, the Senior Assistant Director of Resources and Change in the Public Prosecution Service. You're all very, very welcome to attend this committee today. Thank you very much for your presence. Have you an opening statement?
We do. We have two for good measure.
Right, okay.
I think we initially thought we were maybe going to appear separately, and then the committee decided to have a joint session. But we've obviously shared our opening remarks, and hopefully there's not too much duplication. I think mine will focus a little bit more on the wider systemic issues, and then Gary will focus on some of the PSNI initiatives and some of the joint initiatives that we're working on together.
Okay. If I could just ask, if you have already sent it verbatim, then you should assume that the members have read it. If it's different, then certainly go on ahead.
These haven't been shared in advance, so
okay.
That's okay. So thank you for the introduction, Chair and committee members, and I've already indicated sort of the running order that we're going to adopt, and I'll start. Gary will then make his opening comments, and then obviously we're here to answer your questions. In my opening remarks, I would like to provide an overview of the scale of delay and demand in the Crown Court, to provide our perspective on the main causes, and offer some observations in relation to how we might all act collaboratively in order to address it. I have focused my comments on cases in the Crown Court, as that is where the delay giving rise to the greatest public concern arises, albeit I recognise it's not an issue solely confined to the Crown Court. Thought I'd set the context with some figures that are important and illustrative. The median number of days for a Crown Court case to complete is approximately 750. That is the time that it takes from the date that the offence is detected or reported to police to the conclusion of the case in the Crown Court. Unfortunately, that figure is approximately 200 days higher than it was 5 years ago in early 2020. A second important figure is the number of live cases in the Crown Court, which currently sits at approximately 1,280. The level in early 2020, prior to the pandemic, was 670. That's an increase of 91%. The number of cases in the Crown Court increased to over 1,200 within 18 months of the pandemic. It was brought back to below 1,000 in April 2023, but the general trend since then has been an upwards one, which is obviously concerning. In my view, these two trends, the increased levels of cases in the court system and the increased delay, are obviously linked. A system that becomes more and more stretched becomes less and less efficient, as a limited number of practitioners spin multiple plates and are unable to focus sufficiently on individual cases to progress them meaningfully towards a conclusion. Those cases that require trial have to join a longer queue of other cases also awaiting trial, with a set number of judges, courts, and practitioners available to deal with them. A third figure of some significance is the number of cases that are entering the Crown Court each year. 2024 saw 1,505 cases entering the Crown Court, which was the highest since 2007, and that's as far back as my figures went, save for 2021, which represented an anomaly as we recalibrated after the sharp pandemic-related reduction in 2020. In terms of this current year, 25 to 26, we can see in our own data, our PPS data, that there is an increase in PPS output of indictable decisions, that's decisions to prosecute in the Crown Court, of 13%. We assess that this is mainly due to efforts that we have taken to address some long-standing backlogs, which hopefully will not be recurring, but also to a lesser extent an increase in the number of certain types of cases, including those with a charge of non-fatal strangulation, being brought in the Crown Court, which is likely to be recurring. Therefore, the short-term pressures on the Crown Court from increased levels of demand are likely to rise further. And a further consideration, of course, is the impact of the withdrawal of services by the Criminal Defence Bar, which means that there is currently a very low disposal rate. This will be driving caseloads and delay up further. When the withdrawal of services ceases, as we all hope it soon will, the demand from dealing with the increased volume of cases before the court will make it more difficult to give timely attention to new cases received from police that require a decision from the PPS. It is also worth noting that the withdrawal of services in relation to homicides and multi-complainant sex offence cases, which commenced towards the end of 2024 and has been continuing since then, means that the current caseload sitting in the Crown Court is likely to have a large volume of these serious and complex cases. And finally, in terms of context, in terms of looking forward, we have direct committal going live in November 2026. This will result in a significant portion of the Crown Court's future caseload being fast-tracked into the Crown Court after a single appearance in the Magistrates' Court, with an increased need for early engagement between police and prosecutors, and also between prosecutors and the defence, and greater levels of active judicial case management from the early stages of certain cases. There is no doubt, therefore, that the pressures in the Crown Court are very significant, and we need to understand and be realistic about the current situation and the challenges that lie ahead. In terms of causes of the increased demand and delay, I will quickly highlight 6 factors. Firstly, the data shows that a dramatic increase in the Crown Court backlog can be traced back to the period after April 2020, obviously related to the pandemic. The caseload in the Crown Court rose from 670 to over 1,200 cases by October 2021, and we've never been able to get it back to the pre-pandemic levels. The system and everyone working in it is spread very thin, and as I said earlier, that undermines efficiency. Second reason, funding. The Justice Minister has stated that our department has experienced significant levels of underinvestment since its formation in 2010. And the proportional budget strength of the Department of Justice has declined, while demand on the justice system as a whole has risen. In terms of the PPS budget, since 2015-16, we have seen inflationary pressure of 40%, but our budget has increased by only 22%. Thirdly, complexity and profile of caseload. We are living in an increasingly digital world, which is undoubtedly complicating investigations and subsequent prosecutions, both in terms of the evidence to be used in trials and the material to be considered for disclosure. The number of cases involving sexual offences that are dealt with in the Crown Court has increased significantly, and these rarely resolve early, and indeed many go to trial, requiring all the resource that entails. Fourth, inefficiencies. These exist across the system. No doubt this arises in part because the system is made up of a number of independent organisations with different pressures, demands and priorities. And we accept that there's more that we can do to increase efficiency within the PPS and as regards our interface with police, which is a key focus of the work that everybody on this panel is involved in. This is to be distinguished from the immense effort that we see our staff put in every day in pursuit of a role that they undertake with pride and commitment. But we do see issues with the quality of police files and supervision that leads to back and forth between investigators and prosecutors in order to get things right. Late service of defence statements and disclosure applications can cause further delay and lead to ineffective trials. Lots of administrative work is involved in copying and serving hard copy papers in a system that needs digital transformation in a joined up way. There are too many adjournments in the courts for a variety of reasons. More detailed work is being undertaken in that regard, but the most recent data suggests that approximately 11% of these are at the request of the prosecution, 51% at the request of the defence, and 38% at the behest of the court. And last but not least is the culture of the system. We have an adversarial system where delay will often work in favour of a defendant. Dragging a case out can, in certain types of cases, lead to a victim withdrawing their evidence, or generally just being so keen to move on with their life that they will be content for the case to be resolved by way of a plea to a lesser offence. Submissions to have the sentence reduced on the basis of delay will be made, and discount on account of delay is sometimes afforded to defendants. The main disincentive for delaying any guilty plea, i.e. the reduction of credit, is not particularly strong in this jurisdiction, as considerable flexibility is left with judges to award high levels of reduction even when the pleas come late in the day. That culture is reinforced by financial incentives built into the legal aid structures, which result in significantly enhanced fees payable where guilty pleas are not entered at the earliest opportunity. So finally, just to come briefly to some solutions. The committee may be aware of the work undertaken by a team in England and Wales led by Lord Levison, which has been looking at how to address the backlogs that have arisen in their courts. His firm view, with which I respectfully agree, is that tackling the problem requires a combination of resources, structural reform and improved efficiency. I've already mentioned resources and the fiscal challenges that the justice system faces, in particular in relation to dealing effectively with the growth in the most serious and complex prosecutions. We recognise the importance of delivering reform, but need to be supported to do so. The introduction of some fundamental and essential reforms, such as direct committal, are likely to result in transitional increased costs, but should deliver the desired timeliness and cost savings in the longer term. However, when it comes to structural reform and efficiencies, I believe that we do have the right priorities as set out in the Department's Speeding Up Justice Plan. So to briefly summarise, structural reform involves the implementation of direct committal and increasing the jurisdiction of the Magistrates' Court. The former, which is due to go live in November this year, involves cases involving an indictable only offence directly transferring into the Crown Court after the first appearance. As I stated in my evidence to the Committee on Direct Committal back in 2021, the concept is sound, but we must have in place arrangements to manage these cases differently than we do now, and we need to collectively drive a change of culture that allows for the service of proportionate evidence, fewer, more effective hearings, and the earlier resolution of cases that result in a guilty plea. The increase of the jurisdiction to the Magistrates' Court, I believe, will be a matter potentially for the next mandate. The idea there is that we allow the Magistrates' Court to deal with some of the lower-end Crown Court cases and allow the Crown Court judges to focus on the remaining more complex cases. This is unlikely to be straightforward or uncontroversial, as demonstrated by the recent debates in England and Wales regarding the potential restriction of the right to trial by jury, but it does have the potential to make a significant contribution to the reduction of delay and the creation of a more sustainable, longer-term criminal justice model. Linked to structural reform, but also a key efficiency initiative, is the increased use of out-of-court disposals. As the committee knows, this involves dealing with lower-level offending in a more proportionate and efficient way. I know that there's a session next week dealing with the recent consultation, and so I'll not say more about that for now. But in general terms, it is an important efficiency initiative, but also a facilitator for any change to the jurisdiction of the Magistrates' Court, as it will need freed up capacity. There's another initiative that I know Gary's going to mention in terms of the no file decision, so I'll not say anything just about that for now. But finally, I would just say that each part of the criminal justice system must strive to become more efficient in the work that it does. For the PPS, that includes continuing efforts to work collaboratively with police through the Working Together Programme Board to improve file quality, charging practices, to maximise the value of earlier involvement of senior prosecutors in cases likely to go to the Crown Court, and to develop improved lines and means of communication when it comes to advice and interactions more generally. It also includes greater digitalisation and use of technology. From a technology perspective, the criminal justice system and its component organisations are digitally enabled and interconnected through the Causeway solution. But there are significant benefits to be gained from investing in modern paperless solutions which directly engage legal representatives, leverage the benefits of AI, and provide real-time performance management information. So I appreciate, thank you for bearing with me there while I went through those quite detailed introductory remarks. But it obviously is a large topic and there's quite a span, and I've tried to cover that as best I can. I'll now pass to Gary, who'll take you through the PSNI's opening remarks.
Thank you, Michael. Good afternoon, Chair, members, and thank you again for the welcome and the opportunity to speak to you today regarding delay in the criminal justice system. As a police service, we do recognise the impact this has on victims, their families, the wider community, and indeed confidence in the criminal justice system as a whole. We are fully committed to play our part in reducing delay across the system in line with our key priorities of being victim, community and workforce focused. Firstly, I believe it is important to briefly set the broader context that policing finds itself in 2026. Whilst we very much welcome the reduction in overall crime levels, it is clear to see that the complexity of crime today has increased, as Michael has outlined. This includes increases in sexual offences, increased reports of non-recent offences, and with over 97% of our population with access to a smartphone, significant increases in digital material and associated lines of inquiry. In fact, the vast majority of our investigations, over 95% of our investigations, now have a digital footprint. This is against the backdrop of a reduction in funding in real terms of the policing budget and decreasing police officer numbers in recent years. What's clearly we do not, as a police service, operate in isolation. In the broadest sense, PSNI are responsible for the first two stages of the criminal justice system. Stage 1, where the offence is reported to police and when the suspect is either charged or informed that they would be reported. Essentially the investigation aspect of reported crime. And Stage 2, from when the suspect is charged or informed that they would be reported to the point when a file is submitted to the PPS, the file preparation aspect. Other stages include obviously PPS decision-making time and then first hearing in court to ultimate disposal. It's also recognised that the quality of police investigation and associated file build standards impacts the ability of our PPS colleagues to make prosecutorial decisions. We are working hard to improve overall file quality to help address any needless delay at the PPS decision-making stage. PSNI has actively sought to address delay by focusing on the following three key areas: technology and innovation, people and performance, and partnership. And I think it might be helpful for the committee if I just take a brief couple of moments to provide a broad overview of those key initiatives that we've taken so far to speed up the investigative process across those thematic areas. In respect of technology and innovation, we've delivered a number of technical solutions to enhance service delivery, accessibility to victims, and reduce the bureaucratic burden on our very busy frontline officers. Such examples include a new process for file submission, which sees this completed electronically, ensuring that files arrive at our case management teams instantly, rather than the standard 7 to 10 day turnaround time. We've also introduced digital electronic statements, which modernises the way digital evidence is captured. These statements can be completed remotely at a time and date of the victim or witness choosing, ensuring maximum convenience for the public. Capturing statements in this format uploads documents instantly, reduces the need for scanning, and reduces the burden on frontline officers and staff. We've recorded over 100,000 statements in this way over the last year. We've also developed a new voice-to-text capability which automatically transcribes suspect interviews and achieving best evidence interviews, which historically took several hours and days to manually transcribe, frontline police officers manually transcribing interviews. Over 9,000 hours have now been saved using this software since it was launched late in 2024. We're now scoping further enhancements to this technology, such as self-service, where officers can access this directly rather than through case management teams, and automatic summarisation of interviews, further reducing the administrative burden and speeding up the process. Work is now ongoing to further speed up the file submission process by repurposing that freed up capacity within typing resources as a direct result of this initiative. As you know, we've had an online reporting function for reporting crime for some time now. We've seen a doubling of online reports in the last year, with almost 900 reports each week. And to complement our online reporting offer, we now have a victim portal where a victim can log into their account, obtain the latest status of their investigation, and also communicate with the investigating officer at a date and time of their choosing. This work works alongside our evidence submission portal, where members of the public can instantly upload digital evidence such as CCTV, Ring doorbell, dash cam footage directly to us without the need for a police officer to physically attend and to collect these, all increasing convenience and reducing delay. 70% of our digital evidence is now received via this portal. In respect of people in performance, we've created a number of officer posts to facilitate a gatekeeper function. These are officers of inspector rank who, amongst other duties, undertake a role of ensuring appropriate file and investigative quality prior to investigation files being submitted to the prosecution service in specific case types. These officers act as a quality assurance function, ensuring relevant lines of inquiry have been pursued and the file is built to the correct standard and quality. This is in addition to first-line supervision checks. In terms of enhancing file quality, a range of training takes place from student officer training, crime training to ongoing CPD in file quality and standards, with gatekeepers being aligned to specific geographical areas. We have also developed a comprehensive performance framework from a strategic, tactical and operational level, where key performance indicators are measured and assessed around file quality, timeliness and victim updates. There's still work to do in this area. Now that our timeliness regarding file submission has improved, we are redoubling our efforts to focus on file build and quality. In respect of partnership, PS and I work collaboratively with other justice organisations. We are members of the Criminal Justice Board, chaired by the Justice Minister, and are key partners in the DOJ Speeding Up Justice programme, a programme that has a number of working groups, including out-of-court disposals, chaired by PS and I. This group is scoping a number of initiatives to deal with lower level and appropriate cases outside of the court setting, including expansion of community resolution notices, penalty notices, and the no file decision project, which has reduced overall no prosecution process from 101 days to 43 days, saving approximately 4,000 hours. All of these seek to deliver a speedier resolution for victims with appropriate and proportionate outcomes for offenders, freeing up capacity to allow courts to deal with other matters. PS and I also work closely with the PPS on a bilateral arrangement through the Working Together Programme Board. Through this arrangement, we have agreed appropriate and proportionate file builds, ensure joint working and training in respect of file quality, and seek to modernise processes such as the service of summons and early engagement. A bilateral operational efficiency group also meets to discuss operational matters in an attempt to resolve any issues at the earliest opportunity. Challenges do remain which contribute to delay, for example obtaining evidence from third parties, such as medical evidence from medical practitioners, A&E notes for example, and reports from social services. There can be delays within cybercrime given the substantial increase in exhibits with the digital footprint and the processing of such as I've previously outlined. It will also take some time to recover and to increase police officer numbers through ongoing recruitment to recover the service to sufficient levels, which will also assist in driving file quality and investigative standards. Despite the challenges and further work required, there are positive outcomes that can be seen. PSNI issue around 800 community resolution notices each month, diverting appropriate cases away from the court system. We have taken approximately 4,000 no prosecution files out of the system, freeing up capacity for investigators and PPS prosecutors. And there are proposals to expand penalty notices, as we will discuss next week. Overall, our organisational file timeliness has improved, with files being submitted on target 81% of the time, with median investigation timeliness at 22 days. We have seen a reduction in the overall number of files which require further information from the PPS. However, further work is required on those file types that are more complex, such as indictable report files. Overall, crime is down by 2% on this period last year, and our crime outcome rate is 21.4% for charge and summons and 8.2% for out-of-court disposals. This compares with the average in England and Wales of 7.3% and 3.8% respectively. However, we are not complacent and continue to scope opportunities to reduce delay through the investigative and file submission process, engaging with partners and investing in technology. It's a quick whistle-stop tour of everything. I'll stop there. Hope this has provided a broad overview of where we are as an organisation and just some of the initiatives we've taken so far, and we are happy to take your questions. Thank you.
Thank you very much, both Michael and Gary, for that. And again, we appreciate the whistle-top nature of it because we are struggling for time. So I'll go straight into questions. And Brian, if you want to go first.
Okay. Michael,
Gary, those were two very good presentations, actually quite practical. So I want to pick up some of the points. I'll start with your last point, Gary. And Michael, would you agree that the number of cases requiring additional information from PPS has decreased? Without putting you on the spot in front of them.
And Gary and I talk about this, as you can imagine. Yes. So I think Gary's referring there to data that relates to all the file types across the PPS, or across the criminal justice system, which will include a lot of low-level motoring offences where the file quality is fine, but the complexity of the investigation is quite low. And I think the point that Gary was making there was whenever we see investigative complexity increase, we do tend to see the rate that prosecutors need further information from defence to increase. So, we do have more detailed analysis of this, particularly in relation to domestic violence cases where we're running some particular pilots. But at a broad level, in terms of what we call our case rate 1 to 4s, which are sort of the more serious half of our casework, we tend to see requests for information sitting at about 58 or 59% in those cases.
So 58, 59?
58, 59%
of cases
of cases of that level of gravity require further information from police before a decision can be taken.
Right. Right. So it's around 60% are being sent back effectively.
There can be many reasons why a request for further information issues. Yeah. Okay. Sometimes it might be because the police investigation has missed something. Sometimes it might be because the material that is required, police have not been able to obtain it within that time. So it's a little bit rough and ready in terms of a file quality measure. Some cases that require requests for further information might still be good files. They might just need the 1 or 2 missing pieces. Other cases, there might be more fundamental problems in them that need to be fixed.
No, I think just to come back on that, and I have in my comments I said, so overall as an organisation, in terms of the request for information, it's sitting around 14% overall in terms of the 38,000 files that we submit to the PPS.
14%?
14% is the
back.
overall figure. Well, it's not sent back, it's just a request for further information. Yeah. But in those more complex indictable report file types, Michael has said, it does increase obviously as a proportion, and that's to be expected. I outlined some of the difficulties there in terms of third-party material, in terms of cyber investigations. And sometimes we are just in a position where do we hold up the whole file, waiting on any notes, for example, or do we push forward with the file in terms of everything else that's ready to go to enable that decision, to enable the investigation to progress through the system with follow-up evidence then to be presented. And that's just clearly a decision we would make sometimes, but overall it would be around 14%.
Okay, out of all cases?
Out of all cases.
Okay, no, that's helpful. Because you both highlighted that as an important area for speeding up. So, okay. I was interested in what you said, Gary, then you've mentioned it again, about other statutory services supplying information and services where their primary purpose is not justice, health. It's about keeping people well, helping people get better. Could you say more about that in terms of, so that's about, working across, we would call it working against siloed thinking, about different departmental responsibilities from an assembly point of view, working together for an overall positive outcome.
Yeah, and I mean there's processes that need to be obviously complied with in terms of data protection, and we need to get obviously victim and witness consent around some of that, which just takes time. But we just find that having made the request, for example, it may be GP notes, any notes as I've said, there may be other cases particularly involving vulnerability where there's maybe child abuse cases. There's usually a huge amount of third-party material in terms of social services notes which can take time just to gather up and to be presented. Of course they need to be redacted in appropriate places. So I think we work well with other agencies. It's just by the very nature of it takes time. And as I said, we wouldn't necessarily want to delay the overall investigation waiting for absolutely everything to come in. The other piece around delay is probably an internal piece from a PSNI perspective, just in terms of the sheer amount of cyber related inquiries and phones that need examined, laptops, and the sheer amount of information and data can now be, I suppose, retained within people's smartphones. Takes a long time to analyse and to create reports. Again, a lot of redaction issues as well, which just takes some time. Hopefully that maybe, is there anything more, Molly, you want to say in terms of?
Yeah, I think I can add some helpful information in relation to the medical aspect. So our working relationships with the various trusts and GPs is actually really good. So we do have dedicated staff in one of our current case management teams who are in constant contact, for instance, to get any notes which may allow our PPS colleagues, for instance, to make an early decision about the level of the offending based on the A&E notes. I suspect a lot of the delay is trying to find the actual doctor, the actual consultant, who of course then needs to find their own time to sit down and make a statement and provide that to us. So the interoperability between the two sides, both us and the health, are good. The delays are more in relation to, can the consultant find the time to sit down and actually put pen to paper to provide that material to us.
Okay, no, it's something I think we can highlight, you know, at a senior level. We need to ensure that cooperation is there. I was interested in what you're saying, Michael, about what could be seen as incentives to slow the system, both in terms of, you're saying sometimes it's seen as helping the defendant, and also in terms of legal aid payments.
Yeah.
So, yeah, how do we work against those incentives?
So, yes, and taking the legal aid situation first, it's a difficult problem, but I think the first thing to say is it's pretty well recognised, and in a lot of conversations that we've had with practitioners and with members of the judiciary, particularly in the context of a pilot that we were trying to work up and go live, we were getting some fairly open feedback around this being an issue and something that would need to be addressed if we wanted the pilot to work, which was about getting guilty pleas as early as possible. It's not unique to Northern Ireland. The DPP in England and Wales, Stephen Parkinson, has spoken about this. I think they have some similar structural issues. And really what it means is that if one has a case that arrives in the Crown Court and there's a plea of guilty to all the charges at the arraignment, there's a fee called a GP1. Okay. However, if the defendant pleads not guilty to any of the charges at that point, they can mark a different type of fee, which would, on an average type of a case, see the fee increase substantially. I can't remember the exact amount, but we're talking maybe 60-70%, something like that. You know, enough to make a very significant difference. And realistically, I think we see evidence of this happening. Day in, day out. I had a case where we were being encouraged to return it for trial, and because there were full admissions, and we got the PE papers out extremely quickly, and the case got up into the Crown Court, and there was two counts, and there was a plea of guilty to one and a plea of not guilty to the other, and then a plea of guilty to the second one a week later. You know, and it just seems to be strange, you know, that's happening, but I think it's getting the right balance is difficult, because I understand, you know, that if one's designing a fee scheme, one wants to reflect any additional work, and so if a case pleads not guilty and is prepared to a further extent, there should be additional remuneration. What I'm concerned about is that the balance isn't quite right at the minute, and that a not guilty plea is very much encouraged, or it's incentivised within the legal aid structure, such that we are seeing more not guilty pleas, and I believe we would if we didn't have that disincentive within the system. I think linked to that is the other point about the reduction in credit. So at the minute in Northern Ireland, the maximum credit that's generally afforded is a third from the sentence, if an early guilty plea at the earliest opportunity. But the longer a case goes on, one will see that generally reduce. But even if the case goes on for a long period of time, with the case hanging over the victim, if there's a plea very late in the day, you know, just before the trial, which can be, as we know, years rather than months after the arraignment, and there can be that enduring anxiety for the victim, the reduction in sentence can still be 20 to 25%, and that's the guidance that's set by our Court of Appeal. And even the guidance is that it would usually be 20 to 25%, but that the judge can grant more or less, depending upon the circumstances. So my own personal view is that that is not acting as a very strong incentive to the types of behaviours that we want, you know, which is as many people as possible to plea.
It should reduce more sharply.
So there needs to be a clear differential. And you know, in England and Wales, we contrast our model with the one in England and Wales. They have clear sentencing guidelines, to which the judges are generally bound. I think they can depart from it if there's exceptional circumstances and they explain why they're doing it. But really you have a third, but if it gets to the day or to the door of the court, it's down to 10%. And we've actually did a bit of a study visit over to Leeds Crown Court, and it was quite striking. We saw the judge address the defendant in the dock and really say, do you understand that this is your last opportunity to get maximum credit? And if you don't do that, your credit will fall off a cliff, was the word that was used. And we saw a very striking example of where the defendant asked for some further time to consult with their counsel and entered a guilty plea, half an hour later, effectively. So those are some of the incentives that are at play, and I do believe contribute to some of the delay that we see in the Crown Court.
Okay, well, that's very helpful. Okay, thank you.
Connie?
Yeah, thank you for coming in today. I wanted to ask a bit more information on your no-file decision. I understand that was a pilot, and just really keen to hear the kinds of cases that you're seeing the no-file decisions be made on, and how that's been communicated to victims especially. Is there, some I imagine would feel disappointed that that's been done, and I'd just be interested to hear a bit more information about that.
Yeah, so in terms of, I suppose, the main drivers for no-file decision, we were sending around 8,000 files a year to the Public Prosecution Service with a no prosecution recommendation. The PPS were agreeing with us something like 97-98% of the time. And I suppose historically, in the past, as a police service, we would have been able to deal with those kind of cases internally, essentially writing a report. The investigation is complete. All lines of inquiry have been pursued, but actually the evidential test is not met. So we used to be able to do that, and then we got into a space of having to send everything to the PPS. That was creating an administrative burden essentially on our frontline officers, on our case management teams, on the PPS as well, and we felt that there was potentially room to return that decision making to police. We have a number of safeguards in there in terms of it is not about the investigative quality. Investigations need to be pursued robustly, and we have a very clear decision making process within policing, where at the end of the investigation, where it is felt that the evidential test is simply not met, there is no likelihood of a conviction. That can be recommended by a sergeant and will go to an inspector for decision, rather than creating a whole file to go to the prosecution service. As part of that, we've also built in a victim right to review, which we hadn't had, I suppose, previously in terms of other police outcomes. So victims will have the opportunity, and similar to the PPS process of a right to review of prosecution decisions or no prosecution decisions, we've built that in, and that will potentially, at the request of a victim, that case will be looked at by an independent inspector just to check the decision making around the fact that it's essentially a no prosecution or no file decision. We've also got some quality assurance mechanisms in there as well. The PPS will come in and dip sample our decision making just to ensure that it's consistent, and we're pleased to see that continues to be consistent. And we write the victims as well, so we keep victims updated. The view of the victim is taken into account as well, and we devised that whole process in partnership with victim support and with the Victims of Crime Commissioner. They were all engaged through that whole process. We conducted an interim and final evaluation. The benefits were clear, I think, to both organisations. And that's essentially been adopted as business as usual now through the Working Together Programme Board, and it's one of the key initiatives through the Speeding Up Justice Programme as well.
Yeah. Can I add one thing? I was going to add one thing just in relation to victim feedback. So part of the entire process, in addition to the right to review, is we're very actively looking at best ways to get active victim feedback to make sure that we're kind of collating that and getting a real kind of almost lifetime feedback system from them. So that's a piece of work which is ongoing under the kind of Working Together Programme Board setup.
Just add a couple of small points to that. This is moving to the position as exists in England and Wales. It's been a bit of an anomaly within Northern Ireland that we took a very sort of risk-averse approach post-2000 to submit all these files to the PPS. And so it has been a bit of a cultural change to actually make that move, but I think that's the space that we're all in. We very are much efficiency focused, and the efficiency sort of delivery in this has been quite compelling. I think Gary maybe in his opening mentioned the timeliness, so we're really getting the same outcomes, but we're getting them much quicker. There's an improvement of 57% in timeliness. and the quality remains high, and the fact that we have the quality assurance in place is key to that. You asked about what file types. The way we've divided it up is, I mentioned case weight 1 to 4 a moment ago. The PPS also has what's called case weight 5 to 8s, which are the lower level offending. Now, some of them can be, we're not saying that they're all not serious, but the lower level types of files that we get from police were the files that we thought it was appropriate to start a process like this with. In England, actually, this would apply to all offences, including serious sexual offences. If the police do not believe that a file meets the evidential thresholds for a decision, they won't submit it to the CPS. But we certainly didn't want to go that far at this stage. We wanted to take a more cautious approach and to test it with those lower level files. We do have a number of criteria that would exempt files out of that. So anything that might give rise to particularly public concern or issues of potential independence for police. And I think there are certain types of domestic violence offences where there's high risk victims and so on. So, and the design of the process was very heavily influenced by the engagement that we had with stakeholders. We had a number of really intensive engagements with them, and including a sort of a full briefing on the final evaluation just before Christmas. And they were very, I think initially there may have been a little bit of concern from their point of view. Is a victim going to feel that they're not getting the same service if it's a police decision maker rather than a prosecutorial decision maker? But I think they appreciate the care that has been taken with it, the safeguards that Gary referred to around the victim's right to review, and they were broadly supportive. I wouldn't want to speak for them, but we didn't receive any particular concerns from them about rolling it out as business as usual.
Yeah, thank you. I think that's really important to have that victim-centred approach, and it's positive to hear you're engaging with them. And something that I'm also very concerned about is the rate of attrition of victims throughout the justice system. And I do a lot of work on violence against women and girls and domestic and sexual abuse, and I hear from a lot of victims who just find the whole process really traumatising, and whether that's after they've even contacted the police or after a file's gone to the PPS, they just think either it's due to delays in the justice system, the anxieties they feel around it, they just feel that them withdrawing and dealing with it in another way would suit them best. And I just want to know how what cases you see like this. Is there a lot of domestic and sexual abuse cases? Is there other cases you have concerns around victim attrition rates as well, and any ways you feel we can tackle those?
Yeah, we're probably lacking really reliable data on witness attrition. I know the department shared a report quite recently, albeit it looked at cases between maybe 2018 and 2019, and PSNI may have some data maybe around the attrition at the investigation stage, but some figures that are quoted are very high and very concerning. I think when you look into them to understand them a little bit better, in sexual violence cases, quite a lot of the cases that might be identified as victim attrition cases are ones where the report didn't come from the victim themselves. There's a duty on us all to report a relevant offence to police, and I don't know if certain disclosures are made, and that results in perhaps a healthcare professional or somebody reporting it to police, and therefore you have a lot of cases involving attrition that are in that particular context. And then I think you have a lot of cases which maybe aren't of that nature, but where there's still not a complainant who is ever really intent upon seeing it through from a criminal justice point of view. So a lot of cases drop out. I think the report that I saw indicated a lot of cases drop out even before a statement is made or before an ABE interview, even best evidence interview is made. And then the next stage is the case would come to us, and some the report also looked at what happens at that point, and again some more victims drop out at that point. And the types of issues that are raised are around deterioration around mental health, just this kind of a desire to move on, and it's too much stress and so on. So the report didn't actually find any particular links to delay, but I think recognise that delay is very much built in. Stress and anxiety or deteriorating mental health can be because of the length of time an investigation or prosecution proceeds. In the domestic violence cases, obviously police will do their best to secure cooperation from a complainant, but a big focus that we have within the PPS. I mean, we recognise that sometimes it's an understandable approach that the victim won't want to support a prosecution, but it may nevertheless be in the public interest to proceed with a prosecution. And so that's where the term evidence-led prosecution comes from. It's really about building a case without the evidence of the complainant. And that is something that we do regularly. It's something that we've got a lot of training for our prosecutors on, and it's actually, I'm personally involved in revising that training at the moment to try to make sure that we do that as best we can. So, I mean, it is a factor. It's a little bit difficult to give you some hard data around it. But I mean, just in terms of the early engagement with the victims, assessing their needs, putting whatever support we can in place, those are all the types of steps that I think police and ourselves are undertake in order to try to minimise the impact of attrition.
I think I'll just echo some of Michael's comments there, particularly around third-party reports. We would see that would be challenging to keep victims on board where essentially they weren't necessarily engaged from the outset. We have some very brief operational data which shows a slight reduction in evidential difficulties where the victim does not support. So far this year, this is operational data as well. I just need to caveat that it's sitting around 22.9%. Last year was 27%. But I think it is all about trying to address delay, trying to speed things up, trying to ensure that victims are kept updated as the investigation progresses, ensuring that early support in terms of referrals to victim support, to sexual offence legal advisors, to domestic abuse advocates, the adoption of special measures, ABE interviews, etc., and just supporting that through the criminal justice system to try and reduce attrition across all victim types, and we're very much alive to that. And there's a whole range of initiatives that we've undertaken over the last number of years to try and reduce victim attrition. Particularly the point that Michael just talked there, we talk about kind of that victim-led approach in terms of prosecution in domestic violence, so using the 999 call, using police officer body cam footage, using kind of corroborating evidence. It might be evidence from neighbours, it might be other evidence that's available to try and continue that prosecution where it would be in the public interest. I think you had other points.
I'm able to add into some wider ongoing pieces of work. So the department is about to launch its victims and witnesses of crime strategy, I think publicly next month, and again it will bring in a whole raft of measures to make sure that we're minimising attrition, making sure that we're supporting both victims and witnesses through the totality of the system. So again, that's a specific piece of work that I and some of my team will be directly involved in. Ongoing discussions at Justice Department level about a victim needs assessment service, again focusing in on the same things, trying to make sure that victims are supported, trying to minimise attrition regardless of any opportunity for actual funding in that space. The key partners are already in active discussion about what can we do to make sure that we're supporting victims and again minimising attrition. The Chief Superintendent has talked about some of our links with Victim Support NI. Again, we have really bespoke automated referrals to Victim Support NI. We've been working really hard to make sure that they are as good as they possibly can be. So some debate about what should be shared, what shouldn't be shared, etc. We've worked really hard to make sure that the referrals that should be made are indeed being made, and that's been an active kind of technological piece we've been working on. And then just finally, that whole victim space is clearly very much on the radar of the Deputy Chief Constable, who is the victim champion. And again, just recently, just a few days ago, I've been invited on to the Strategic Community Engagement Group, where I will feed in specifically about victims' issues, so that across the service and any of that work will include a bespoke part in relation to victims and what we're doing to make sure that all parts of the organisation are linking in where they need to.
That's great, thank you.
Okay, I'll just remind members and presenters to be concise in your questions and your answers. Patsy?
Thanks very much, Chair, and thank you for your presentation. 2 or 3 wee questions just. As regards, picking up on you, Superintendent, that bit about active victims' feedback, which you referred to, could I suggest a good part of that would be constables or sergeants lifting the phone and updating people? That is one of the most common complaints I get, that people would say, that doesn't need a computer. All it needs is somebody to pick up the phone and engage with people. Now, I'm not saying that happens in all cases, but it's something, basic human contact, that can help ease people, that at least somebody cares, and I think that's vitally important. If we could maybe just move on over, please, to the facilitated and the accumulation. We'll just take maybe the evidence gathering. And I heard you were very quick to come in there, Chief Superintendent, to establish that in the instance of those 14% odd of cases that were sent back from, that maybe was looking for further information. You could argue from the flip side that that information should have been there in the first place, right? And that brings me down to the role that you've outlined of these inspectors, the quality assurance and enhanced file quality. They're going to have a pretty pivotal role, aren't they? Now, the question is, how are they going to do that? I would venture, I read a fascinating article yesterday by a Matt Schumer on the role and function of AI. And I've even followed it up last night. I was reading, because we're coming in here, that AI is being used by some police services in the United States from body cam to gather evidence and get that all compiled. So have you looked at that, the role of AI? Because it's something that I raised with the Lady Chief Justice whenever we met her as well. The role of AI in quickly and accurately getting together the evidence, compiling and gathering, collating that evidence, which we know can be done, because I'm speaking to business people and they're finding it really, really efficient in doing what they need to do it for. That's the first thing. Then the second thing will be over to you, Mr. Ignew, because in that article from Matt Schumer, it did refer to legal services being something that could very, very quickly find itself being overtaken by AI. Have you looked at that and the possibilities of dealing with that? Because from what I'm reading, from what we're learning, from my very basic experience of it, it's going to make things faster, more efficient, and get to the point where both, I hope, the collation and the quality control, and then ultimately the decision-making point on your part, in those cases where it can be done. There will be other cases where simply it can't be done because it still requires that human intervention. Could you give me some sort of a flavour of what the thinking and direction is at yourselves around that, please?
Certainly.
Well, yes, I'll kick off then. In terms of the victim updates, we do understand how important they are.
Mm-hmm.
We do measure that at an organisational level, and it is feedback that we get fairly consistently, and we continually try and address that. So the victim portal, I accept it's maybe not necessarily somebody picking up the phone, but it could result in an officer picking up the phone if, for example, the victim goes on at 11 o'clock at night and logs into the portal account and requests the update. It could happen, you know.
If they can use the portal.
Well, of course, but
Right.
it's just it's about a suite of options, right? And in terms of the compliance of victim updates, that is something that we closely monitor. The gatekeepers, you're right, critical function. That's why we've pitched it at inspector rank. We bid for additional funding through the DOJ Transformational Fund to secure additional posts. So and we've prioritised them in the area of domestic abuse. So those summary domestic files and indictable domestic files, all of them will be assessed by a gatekeeper before they go to the PPS. Right. And they work under that Working Together programme, and there's a very clear list of what's required in terms of file build, file quality, and we're seeing that start to drive up file quality in that area, which is great to see. In terms of AI, we do have an AI steering group within the organisation. It's chaired by ACC Justice, Anthony McNally, and that is about scoping out potential opportunities for the use of AI across a number of different policing functions, but doing so in an ethical way that's explainable and accountable, and just making sure that we have the appropriate parameters around that. And we always have, if you like, the human in the loop around that. So we're alive to the different opportunities that AI would bring. I think I outlined some of the key innovation and technology that we've used over the last number of years to speed things up in terms of our digital evidence, our digital statements, the use of, I talked about voice to text, for example, and the summarisation of interviews and having all of that done. But no doubt there will be opportunities in the future around the use of technology to assist with file build and file quality and speeding things up. We're not just quite there yet, but we're spoken out a number of opportunities around that. I think, is that it from my perspective, I think?
I think so. Unless you want to comment on whether prosecutors are going to be replaced.
I'll let you take that one.
I'll try to deal with that one. But yeah, just to endorse it, actually, I think your second and third questions are absolutely linked. You talked about the gatekeepers and checking the file quality, and it's been a really important role and a very welcome investment, and we have seen improvements. I think for the next year of our plan, what we're looking to do is to sort of refine and streamline that process a little bit, but very much with an eye to what technology can do to help us with that in the future, because that's a more sustainable model. You know, a gatekeeper, inspector resource is a significant resource. And if some of that work can be done with the use of automatic or artificial intelligence, that's obviously great. And I think the fact that ACC McNally is the co-chair of the Working Together board. In fact, at our last board, we had a very similar conversation to really what you're inviting here.
Right, interrupting, but I take it, are you working on AI on that board?
No, so we're working on file quality and other issues, and there's modernisation and transformation.
Using AI, just to get it clear in my own mind.
So no, we're really at the scope. I mean, as Gary says, we're really at the early stages, because it is quite new to everybody, and everybody, you know, can't really go racing off doing uncontrolled behaviour in this space, because it's quite, I can definitely see the potential for AI to help, but we'll have to be really quite responsible around it, because particularly when you're a public service, you can't really afford to get this wrong, and police and ourselves are dealing with very sensitive information. Okay, in fact, at our planning day just a couple of weeks ago, we had a presentation from an external provider on artificial intelligence and about what that can do in the criminal justice system and for prosecutors. And we've had a trip over to the CPS to see what they're doing on AI. They have a big team, a well-resourced team, as you can imagine. And some of the uses, you know, that have been presented to us around that, you know, related to document review and analysis. If you've got complex material, or, you know, the scope for AI to really help with that and to get through it a lot quicker is great. Automated redaction is another one. Client-victim communication is another one. So I think the CPS have a pilot where first drafts of letters with victims might be done by AI. But I think, you know, that is a good idea, but it needs to be approached with some care, and there needs to be transparency around that.
Totally.
And really, you can see how it could produce a draft, but there definitely needs to be a human, you know, involved in it, and anybody who's receiving that communication needs to be aware of the process by which it was presented. And then I do agree, and the scope for AI to help with the file quality work, as Gary says, it's early days, but in fact we were outside in the corridor. Marty was telling us about a meeting that he had yesterday with one of our I was going to say senior lawyers, he's not a senior lawyer, but one of our modernisation leads, where they were having a discussion about all the work that PSNI are doing in the AI space. And I think what's really important is that we are right beside police. There'll be bits of it that won't impact upon us at all, but the bits that do impact upon the PPS, we need to be right beside police, understanding what's happening and helping them with that. Because this is exactly the type of area where one organisation could be working in a bit of a silo. I think police and PPS have come a long way, and we know to consult on these issues. But this is one where we really need to work.
Thank you for that. Just maybe if I could ask, because often, Chair, with your forbearance, often the private sector is way ahead of what the public sector is doing. And have you had any advice or any talks with some of the big legal firms, whatever they might be? You know, there's some of them located here in Belfast, to say, what are you guys doing?
Not yet. I'll let Peter come in here in a minute. The nature of the work that they're doing would be different to prosecutorial decision making.
But it's legal work.
Yeah, it is legal work.
On the other side of the bench to get time. It's like I get how that works.
Yeah, but a lot of it would be document review and. Well, I'll pass to Peter.
We haven't had any direct engagement with sort of the large private sector legal firms. We have, as we mentioned, we've already talked to the Crown Office in Scotland and the Crown Prosecution Service in England and Wales, just to see how their learning is coming along. We did, in the context, you might be aware from previous presentations, the Causeway system, which is the IT system that joins up all the criminal justice organisations, is in the process of being re-tendered. And as part of that procurement exercise, a number of the suppliers have brought in partner companies who have been specifically about AI and how AI can support the justice system to improve. And actually, some of them, I think, it would be really useful to be able to engage with them and bring them in and say, well, what can you do for PPS? Because some of the examples they gave were from the CPS field. We obviously need to do that in a way that doesn't cut across the procurement, because procurement can be very litigious. But I think there are 2 or 3 companies there who I think if we could engage with them, I think we could probably make some progress quite quickly.
Yeah, that's grand. Thanks very much indeed. Thank you. Thanks,
Matt,
Chair.
Deputy
Thanks,
Chairperson.
Chair. Can I ask, and you both referred to uplift in budget around, specifically around the access to judges and to justice and tackling delays. Do you think that for both organisations those programmes are bearing fruit yet?
I think, well, from a policing perspective, I give a number of initiatives. So the no-file decision is a key outcome of the speeding up justice work. That's around 4,500 files out of the system, but the same outcome and cut down by half the time. So I think that's a real key tangible. We have expanded the community resolution notice criteria over the last number of years. We're obviously seeking to expand the penalty notices as well, which we're going to talk about next week. So I think we're at an advanced stage of that, and again that just allows for proportionate disposal of offences at a much earlier stage. In terms of the file quality piece, I talked about those additional gatekeeper resources, and we've seen sort of embedded now, working alongside our partners in the prosecution service and seeing an increase in the file quality. And that
What about the out-of-court disposals?
Yeah, so the out-of-court disposal, I suppose it was the I think we're up around 800. I don't know what the actual scale of the increment, but it's around 800 a month we're issuing in terms of community resolution notices. The penalty notices, obviously, we're working through that at the minute, and the no-file decision is the other key outcome of out-of-court disposals. And as I say, it's sort of 4,000. It's pushed our other timeliness up as an organisation to around 81%, where it was sitting around the 72-73% before. So taking those files out has allowed officers to concentrate on the other file builds and allowed that sort of processing through case management team, the additional capacity to be able to look at the other file types that are going actually to court and to be able to focus on those. So I think that's probably a key outcome so far, and we're about a year, sort of 18 months in. I think we'll see a huge benefit with the expansion of penalty notices. If we get that over the line and getting that operationalised, that'll be the next stage. And then there's other work that we're doing around restorative justice and stepping into restorative justice space to see that as a key outcome, which we haven't really leaned into as a criminal justice system for some time in a formalised way through the criminal justice system. I think that will bear fruit as well in due course.
Okay.
Yeah, just add to that, obviously the file quality work is very much what we are, I suppose, spending our transformation money on, if you like. And as Gary says, that has seen good increases in terms of file quality in domestic violence cases, which we've aligned it to make sure that we're aligned with government priorities. And then we're only a year into that, and then we're looking to build on it, as I say, refine the process, and try to lean more into the technology side to make sure that we're as sustainable as possible going forwards. We've just started, we've extended that into the indictable cases, the more serious cases. And again, we will see file quality improvements there. But the other thing that we're doing in that space is to seek to have senior public prosecutors looking at, I don't want to get too technical here, but 28-day charge files and looking at those immediately, and then also having case ownership from the first point all the way through the case. We've already seen some really positive results on that. Now, there's only been a small number of cases that have gone through it, but of those cases that have gone through that process, that have been prosecuted on indictment, we have seen them the decisions being issued within 39 days compared to a baseline of 123 days. Now, I would love to say that's a 68% reduction, and I would love to say that it's scalable and it'll be long term. I know it's going to be more challenging than that, but I think we're testing a model there that we haven't really tested before, and the early indications are really, really good. And I'm really quite excited about being able to roll that out over the next year and hopefully come back with some very positive reports on it.
Thank you. Chair, just one more question. You referred there to, and this is for PSNI, around your own internal filing systems and updates to victims. Preface this by saying that we are rarely, if ever, contacted with good news stories, but I can think of a number of cases in the past 6 months where I have dealt with people on really sensitive, traumatic incidents. I can think of one particular example where a family were told they were going to get an FLO appointed. Then they were told no, that wasn't the case, that a constable was dealing with their case. Then I think they had logged themselves over 50 calls in the space of a month, and were told that the constable that was dealing with their case was off on leave and that it hadn't been assigned to anyone else. Zero communication. Then told an FLO had never been an appropriate suggestion in this particular incident, and that an FLO should never have been referred to. And I have serious concerns. I know in that particular family's case, they feel that the incident that occurred, that there has been a cover-up. And I can think of other examples where you have two families going through a similar incident, and one are told that it's a specific offence and crime that will be dealt with in a particular way, and another are told it's not a policing matter at all. Police officers going into a home, not identifying themselves, leaving without leaving a card or any contact information. So that we have the broader issue here around access to justice and how long it has taken to receive results. But even in the interim, there are massive communication problems, and that, I think, is feeding into serious anxiety in our communities around how effective policing is, because people don't feel like they can get any feedback, even let alone a result.
Yeah, and you know that
was efficient.
Yeah.
Yeah, in those cases, it's really disappointing to hear that. And in that particular case, I'm more than happy to look at it if we want to get a chat. You know, just to have a little bit of a look to find out what is going on there, and to put it right if we possibly can. It's not nice to hear circumstances like that. Victim updates are a priority for us, and you know, as I say, we have compliance, we have monitoring processes in place. We can look across different departments and different districts in terms of compliance. We've built that portal to try and enhance that communication with victims so that they can get their updates, they can communicate with the officers. But there's always work to do on that. And I know as part of the work that Marty has referred to in terms of victim needs assessments and that whole journey from the point of referral right through, we're doing a lot of work with partners just to try and enhance that at every point. And Marty, I don't know if there's anything more.
Yeah, I mean, it's just to say, I mean, it's really concerning to hear that. It's really sad to hear that. It's the exact opposite of everything we're trying to do. So even in relation to the quantity of victim updates, we've really been pushing the quality of victim updates. So the victim updates need to be really good and actually, you know, trying to engage. What I can say again is happy to review individual cases. If anybody's coming across an individual case which is concerning, they can come directly in for independent review kind of at my branch level. But we do have really good working relationships with the likes of victim support and the Victim of Crime Commissioner designate. And again, we've kind of said if you're coming across cases which are clearly wrong, things clearly aren't kind of working, then they can come in to me and can be reviewed, and we can pick them up and make sure that those, you know, individual failings, flaws can be picked up and addressed as quickly as we can. But everything you've spoken about is exactly what we're trying to fix within the system.
Thanks.
Okay, Ciara?
Thank you, and thank you very much. I've scribbled up many notes, so it's been really, really detailed presentation, so thank all of you. I've just two areas and I just want to pick up on. One would be with yourself, Gary, and it's about, obviously, and I know a lot of discussions already happened around the file standard and quality. When did the gatekeepers actually be implemented? Because I'm just slightly concerned, and I have to maybe declare an interest that I am currently supporting someone who have went to the Public Prosecution Service, who have agreed not to go forward, but they haven't been happy, so I've been assisting them with obviously the lack of evidence and work that the police has done, so I'll declare that. So I really just want to get a grasp of, because I get a bit anxious when we're speeding up the system and you have a lot of things going on to improve it, but at the same time ensuring, and I'm conscious of the resources that you have on the ground, and I'm conscious of all the digital aspect of cases, that how is it going with regards to resources you have, all this digital information, which is like 90% is involved in your cases, to be able to scribe, write, present, file, and do everything that you possibly can, conscious that there's barriers to evidence in some cases. And you've identified some areas which I'm concerned about, because that's a specific area in the case that I'm working on, where there was no engagement or follow-up with the likes of social services, or there was, and you couldn't get any information, despite the fact it was key information that could present their case. So I just want to get a feel for yourselves, where is that all at regarding the IT, the quality, and how things are moving, and how you're dealing with that based on the resources that currently exist, to ensure that you have the top quality. It's really good to hear that you have that gatekeeping you're looking at the quality all the time, but I'm conscious behind the scenes trying to gather evidence.
Yeah, and I'll maybe kick off and then Marty can come in to support. So I suppose really what I would say initially is when we talk about speeding up justice, we're not talking about compromising quality. It really is looking at those appropriate mechanisms to speed up justice. So for example, we looked at the no-file decision and that was around taking out that lower level crime that the PPS agreed with us 97% of the time. So we were able to take that up, create that capacity to focus on those cases that were actually going to go to court to try and build that. So it's not speeding it up at any cost. It's very much of the mind of we can't compromise on investigative quality and victim care. And likewise with the likes of the CRN expansion, the penalty notice expansion, that's about those lower level cases, disposing of them appropriately and proportionately and in a speedy way that we can again focus on those other cases. So I just want to make that point. Clearly it is challenging because we have the lowest police officer numbers that we've had for a long time. Our demand is is significant. And I talked a little bit around some of the technology that we've been trying to use to try and make us a little bit more efficient around that. There's still a lot more work in the technology field. We've talked about AI today. I've referenced the AI steering group. We're really only starting our journey around AI and the potential opportunities around that, but continually benchmarking across other police services, private industry, talking to other companies around where are the opportunities that we can take the learning to try and help us in that tech space. And I think we have made some progress around that. We continually reviewing our policy and processes just around trying to make things a little more efficient. And the whole piece around gatekeepers, yes, they're in place now.
Yeah.
They've been in place probably as a result, the additional gatekeepers as a result of the transformation fund, and I think have been in place, Marty, for the last couple of months.
3-4 months.
Yeah, so it's still that additional capacity there has just landed, but that's an example of looking at policy and process and a little bit additional resource and repurposing resource to try and get it right first time, because it is a challenge to try and push through files and investigations and to continue. The frontline detectives are under a huge amount of pressure.
Just a simple thing, Gary. So if someone in a case where they give a statement, domestic violence, give a statement through a camera, and then 6 months later, oh no, you have to come down to the station and do a statement, and then a few months later you have to come down again, I've lost your written statement. So 3 occasions for someone, and I know that's a one-off, but is that the type of thing that's been looked at?
Yeah, absolutely. And we talk about CCTV, for example, and we can capture CCTV now on body-worn video, and we've agreed that with the PPS and the local presiding district judge, just in terms of trying to speed things up in for example, the cyber space, where it can take a while to process CCTV. So we're looking at ways to kind of circumvent processes that we can in an appropriate way.
Is that similar to someone's phones? When someone knows there's
probably
information on someone's phone and no one goes to actually check that phone, analyse that phone, doesn't do anything with it. What's the relationship that you have and the control you have to access someone's phone, for instance?
Yeah, well, a phone can be taken as part of obviously the investigation. There's a lot of work through our cyber colleagues within crime department who are looking at trying to speed up the whole triage of phones, the examination of phones. There's work underway around that in terms of even kiosks, so we don't have that single point of entry, if you like. We're now sort of looking at pushing that out to appropriate teams and local teams that they can do that initial triage, so we don't have that sort of single point of entry and choke point, and looking at the structure and the systems and the processes around the cyber, for example. So all of that is being looked at right now, and I think just some of those examples today I think have delivered some real efficiency. So for example, I've talked about the digital ingest of digital evidence, where people can submit over the portal their CCTV or their Ring doorbell. That is not a police officer having to get into a car and travel maybe half an hour to collect it and to bag it and bring it back. That's saving efficiencies. It also actually enhances the service for victims, because they don't necessarily want the police car outside their home address to pick up Ring doorbell footage, so all of that we are seeing. Remote statements, we can take a statement from a witness now. They can do it from the comfort of their home, and the police officers in the station do it digitally. And I think again that we're starting to see real efficiencies around that.
Oh, that's good. And I know the time, so just one last one, and I've brought this up before. I done a short visit day. A court sat in for 15 minutes, and there was about 20 cases. Adjourned. The whole lot were adjourned. I've sat there 15 minutes and went through 20 cases. You mentioned 11% prosecution, 51% defence, 38% the court. What's happening in that field? how can we, and I know all what you've said today, but what's the biggest thing that could happen, could make a difference out of everything that you've mentioned? And
It probably depends what court you were sitting in when you saw cases being adjourned. Those figures that I mentioned were the Crown Court, and they don't really tell us that much, really. It's just at a very high level. I think there is some information beneath it in terms of the reasons for adjournment in the Crown Court. But I know that maybe the Lady Chief Justice referred to the fact that she was seeking to do some more detailed work around that in order to understand it. If you're sitting in a magistrate's court, which you may have been, and it's a charge case, it may be that the investigation is continuing, or it may be because it's at a fairly early stage of the case, in which case there's adjournments, or that the investigation has resulted in a file being submitted that is under consideration and the case is being adjourning. So I don't know your case sample there of the sort of 20 adjournments. It's quite difficult for me to maybe sort of comment on without a bit more context.
well, the conversation, to be honest, what we say is it's the lack of evidence not being brought forward.
But I can only imagine that's maybe just at the early stages of the investigation, and it depends on the nature of the case. Gary mentioned there, some of the problems that they're having with cybercrime, albeit I know that the backlogs within cybercrime were really turned around. I think there was some really, really good work in order to do that. So we're definitely in a better space.
I can make a comment just because it's a recent issue. So Mr MacDonald sits generally on the Speeding Up Justice Programme Board, and at our last meeting just a few days ago, the issue of adjournments came up specifically, and various kind of high level statistics about why there are so many adjournments, what are the reason, and again there's going to be an additional piece of work to try to identify what are the reasons for adjournments. And of course, as Mr Agnew has said, there are a range, including things like maybe waiting for a pre-sentence report and a number of other issues. So it is again an active topic which is being looked at.
Oh, thank you. And look, it was great to hear so much work that is happening, to be honest, and you seem to be on your game, and you have a lot that you are juggling, but it is great. And then likewise, I just want to emphasise the fact the work that you are doing on victims. It's really, really good that you have put a concerted effort on that. And Michael, or Gary also, when you had mentioned obviously exploring the restorative justice, because I think that could really assist, because it's an all partnership approach, and it's about building cohesion across the justice system. So I welcome that as well. So thank you.
Morris. Thank you, Chair. Chair, I'll be brief because most of my questions have been answered. I would just pick up on what Connie was saying there about sexual and domestic violence. From my point of view, it's assaults, intimidation and threats, and drug suppliers who wear people down because they don't get to court quick enough and they just pack it in. So I have concerns over that there, that people who genuinely deserve justice aren't getting justice because of the length of time it takes to get a case to court. And you talked about digitisation, empower, train, support and improve quality. Is there any plans to utilise back office staff to free up the PSNI office for the front line? There's a lot of this stuff can be done back office, obviously PSNI staff, but back office staff. Can that be done? Can that be looked into? And the other thing about AI, AI is a learning process. It's a beast that learns itself. It collects and disseminates information, and it cross-references. So how would you make the digital system that you use, the AI that you use, be contained within your system? Because if it gets into another system, you don't know what it's going to tell. So how do you plan to make sure that that's secure to your servers?
I'll kick off with the AI aspect, and then Marty can just talk about the back office support function. I think he's got some good examples of where we're making progress on that. Everything you've just said are concerns that we're alive to, and that's the reason why we're taking a slow and methodical approach to our work around AI. So in terms of how we do that, that's a very technical question, and I would probably leave that to my colleagues in our Information and Communication Services Department. But just to give you reassurance that all of that through information security, data protection, all of that is being looked at in terms of our ethical use, proportionate use of AI, the use of cloud, to what extent that we use it, what the guidance looks like, what the risk assessment looks like. All of that we are currently alive to and progressing and benchmarking that with with UK government guidelines around use of AI, around the National Police Chiefs Council guidelines as well around use of AI. So we're well plugged into all of that too, in terms of our development of AI. So I think slow, methodical approach to it. There's lots of opportunities and benefits, I've no doubt, in terms of all of this work that we're talking, right from the contact centre in terms of initial contact from members of the public over our 101 system, for example, the whole way through in terms of how we investigate crime, how we build files, how we check the quality of files and submit that to the PPS. Marty, you want to pick up the back office function, please?
Yeah, and just to say an awful lot of what Mr. MacDonald has spoken about what we're doing is very much designed to free up additional hours at the front end to allow officers to do their victim updates, to have better investigations, to prepare better files. So, just one really simple example about some of the things we're doing. A recent collision report form app allows officers now to submit material electronically through that app, and it saved about 70% of the time, both for officers and for the back office functions. And I'm actively involved in my branch review, which has a significant number of kind of back office administrative functions, and that's very much designed in relation to freeing up additional capacity, finding additional resource with a plan to help any way we can at the front end, again perhaps around file quality, file timeliness, making sure we're providing evidential checks, which traditionally hasn't been done within that administrative function, but we're confident we can do that, and again that will help officers have more time, better investigations, better victim updates and better quality files going to the PPS. So again that is an active ongoing piece of work.
Very good.
So I think Gary's right. I think slow and methodical with the AI is definitely right. I think there are a number of constraints that we have. So Causeway at the minute sits on a confidential network, and currently AI isn't allowed to go onto that network. So that's an inhibitor that will need to be tackled as we move forward. The other challenge with AI is normally they are powered by sort of a large language model which sits somewhere else, possibly in the UK, possibly in Europe, possibly further afield. So we're always told that if you are using it with any sort of sensitive material, there are real risks around that. You can build an AI solution which will have guardrails around it. Now, I'm not a tech either, but you can build an AI solution which will have guardrails around it, so you can feed confidential information into it, but it won't go beyond the guardrails. So the processing will still be done elsewhere, but the information is protected. So there are ways to overcome it, but it will take a bit of time to get there.
One thing, Chair, when I'm using sensitive files, I take them out of the system, put them on the desktop, amend them on the desktop, and put them back in again. That way it can't go out accidentally.
Okay, Doug, on remote.
Yeah, thank you, Chair. Michael, I just want to pick up on one of the answers that you gave to Brian, because we are absolutely incentivising not guilty pleas. And that's what's creating the delays, or some of the delays within our justice system. And I think Connie raised the issues of sexual crimes, because the drop-off rate of sexual crimes, it seems to be so much higher, and that's the delay which is causing that. So for any perpetrator who's guilty, just by saying, I'm not guilty, he knows that over a nearly 2.5 year period, that victim might fall off. For one, he gets away with it, or two, right up to the day the trial starts, he could get up to 25% off his sentence. Have you got a proposal that would try and cut out that incentivisation? I know what my proposal would be. My proposal would be take it away completely. You either plead guilty at arraignment or you don't, and there's no more incentivisation. But do you have anything you think that would be useful?
Well, there is a consultation on this, and we have provided a response to the department in relation to it. So I mentioned the England and Wales model there, which I suppose is our closest comparator, which is a more structured and more transparent, I would suggest, arrangement, so that all the practitioners, including the defendants and their legal advisors, know exactly where they stand if they do not enter their guilty plea at the earliest opportunity, and can see the differential that I talked about that I think is required in order to drive behaviour. I think I mentioned my trip to Leeds as well. I thought it was very impactful when the judge confronted the defendant directly with the reality. And I know some judges do raise the issue of reduction in sentence and how that will reduce. I would like to see it perhaps done more consistently. And then I think the final issue is whether we are prepared to go beyond a third for certain types of cases or in certain types of circumstances. Again, this is something that is being considered in England and Wales. Levison makes a recommendation that we do look at that. I think when somebody, technically in Northern Ireland, the maximum credit is supposed to be reserved for those who make their admissions in the police station. You know, not necessarily a year or two later when it, you know, first a sexual offence case first arrives in court. So for those who really do make those early admissions and vindicate a victim's complaint and remove the anxiety of what lies ahead at that very early stage, I think there's a conversation to be had there as to whether more than a third might be appropriate in those circumstances. And again, I think that is something that Gillen talked about in 2019.
And I think you're right. I think you're right, Michael. I think the problem is that late guilty plea, because the victims are still going on what could be 2 odd years of hardship getting ready for a trial, only for the day of the trial to start and they plead not guilty and then get up to 25% off their sentence. I think is a real issue. So I think you raise a really good point.
Yeah, I think I understand the concern about a change like that. I think part of the difficulty that we have, well, I suppose the law is as it is, and I think it probably would require an intervention, you know, to move the dial in relation to how we deal with those issues. We have a lot of cases in the system that are past the first point, if you like, that are past arraignment, and I can understand the concern of many that they want to keep that carrot available in order to clear some of those cases. And you know, the counter argument that it would be made to me in sometimes is, you know, you will have defendants who just won't be ready to plead guilty at the start, and you need to keep that leverage or that incentive even at a later stage. But I feel we need to really just turn it around, and we need to make clear, you know, the incentive needs to be there at the early stage, not at the late stage. And it will be a bit of a hard transition, particularly when you do have cases that are in the system. So if it was going to be changed, it may well be that it would need to be prospective, so that people are entering the system with that new framework, you know, that can inform their decision making, as opposed to those who are already in the system who may have got to a point where they potentially still do want to plead guilty, but they need some sort of incentive to do so.
And it's interesting, Michael, if I can just move on, because we are talking about the delays in the justice system, and I'm always solution focused in regards to that. I think we always need to be solution focused, and I'm looking at solutions and how we do this. And one of the discussions I had with the director was, should we be increasing the mandate of our magistrates court? Because you've already talked about non-fatal strangulation, which has now moved from the magistrates court to the Crown Court, and I believe that's because of case law that said that animates that the sentence should be 3 years or that's a sentence line, but that's outside of the magistrates' remit. That's why it's gone into the Crown Court. Should we be increasing the powers of the magistrates' court, and would that alleviate a lot of the problems that we're seeing in the Crown Court?
Yeah, I mean, I think that's definitely part of a fundamental part of the Speeding Up Justice plan. We're at early stages with it. You know, I think there has been some scoping as to what an increase in the jurisdiction to maybe 2 years or 3 years would do. It would actually take quite a lot in terms of volume of the Crown Court work out of the Crown Court and into the Magistrates Court. And that's, well, you know, that's what we need to do if we want to deal with the increasing demand in the Crown Court and the increasing complexity and the increasing delays. We need to free up some resource. I think in my opening comments I mentioned the fact that it's not necessarily just as straightforward. There'd be all sorts of sort of related issues about removing rights to elect, you know, for Crown Court trial in certain types of cases, as well as maybe just increasing the jurisdiction of the Magistrates Court. But absolutely, there will be a detailed consultation, I hope, at some point in time, which will set out all the advantages and disadvantages to it and all the nuances of it. And then I think everybody can really take an informed position at that point.
I think
that's not going to be...
Sorry, Doug.
Go ahead.
I think Michael mentioned earlier that obviously the Levison proposals had created some pushback in England and Wales, and there are differences between England and Northern Ireland. I mean, England and Wales, although they do have some professional magistrates, a lot of the courts still use the bench of 3 lay magistrates. the district judges here are obviously all professionals, so I think it is a different proposition in Northern Ireland, and I think the argument for making the change is probably more positive.
But this is still something that'll take quite a long time to you think to get in place, and it's not gonna alleviate the problem we have now. This is gonna be years down the road if we decided to move that way. That's fair, isn't it?
I think that is fair.
I'm just going to make a comment again, just to be helpful. So there is again an active working group looking at the remit of the Magistrates Court. I sit on that. It's one of the work streams under the Speeding Up Justice Programme Board. So we're at that scoping stage, looking at some of the strange anomalies between sentencing powers and length of sentences between the Magistrates Court and the Crown Court. So again, active piece of work, and we suspect at some stage we will go out to public consultation.
And a very, very last brief question, Michael, if I can, and Gary, you can jump in if you so wish. I have a real concern about victim support and victims' care and the haphazard manner, and I don't mean that in a negative way, but we have so many different groups which are dealing with victims' care that many victims and their families are falling through the cracks, and I see it all of the time. And one of the issues is the victim information scheme is an opt-in scheme, where I believe it should be an opt-out scheme. In other words, everybody's involved in the victim information scheme unless they make an obvious choice to come out of it. What do you think about that as an idea?
The victim information scheme that's a post-conviction, post-release scheme, isn't it?
It's run by the prison service. About early releases.
Well, no, it's run by the Department of Justice, the Victim Information Scheme, so that people get information about those who have been convicted and possibly are coming up for either parole or coming up their time served and into licence, and different people are dealing with it. The problem that we've got, for example, is that we've got people who are completing their time behind bars and being released back out into the community, but victims' families aren't being told that, and likewise, we have victims' families who suddenly notice that the guy who murdered their loved one has suddenly been arrested in Portugal and now is now facing extradition, but they find that out in a newspaper. So I'm just wondering, how do we close that gap? And I'm just thinking, is it by having an opt-out scheme as opposed to an opt-in scheme?
I don't know, but given the nature of the scheme you're talking about, it's probably not for either the PPS or the PSNI to talk about. It really is for the department. However, I think I can see some challenges with the opt-out scheme. Some people, whenever they get to the end of their trial, just want to put it behind them and close it, and sort of giving them information unsolicited. I think you could see that as potentially being problematic. It would certainly go some way to addressing the issue that you said, but maybe it's more about how we share information about the scheme, how we make sure that they know what the benefits are of opting in, how they know to keep in touch with us. So some people will move on, and maybe we will lose their contact details. That's the royal we. We'll lose their contact details, but I'm not sure I would go for the reversal of the opting solution as the first choice.
The only other thing I would add, just in terms of at the very, so you're talking obviously at sort of prison release stage, but at the very early stage of the investigation, it is an opt-out scheme in terms of the victim referral to victim support. So that will automatically be completed unless the victim opts out. But that's it's something different to what you're talking about. But just to give you some reassurance that we do look at that sort of opt-in versus opt-out scheme, and we've taken the decision in terms of that initial referral to victim support that will be done automatically.
Good enough. Listen, thank you, Chair.
Okay, Aoife.
Thanks. Can you hear me? Okay, yeah.
Yep.
Yeah. So look, I'm going to go back slightly. You've spoken about the PSNI being trauma informed, and I acknowledge the commitment. However, I want to raise concern around the practical application of the approach where officers are not properly trauma informed. We see situations where victims are subject to repeated questioning, unnecessary credibility challenges, or what can seem like speculative or dubious counter allegations, which I have seen with constituents come in my direction. So not only does that cause further harm to the victim, but it also consumes significant police time and resources. So I suppose my questions are, I have two questions, I'm going to give them together. So are you tackling whether poor early decision making is leading to unnecessary investigative work and delay? And do you accept that failings to recognise these dynamics not only re-traumatise victims but diverts valuable PSNI resources?
Well, maybe start with the last one. So clearly, again, tragedy for us, and more importantly the victims, if we are in any way overly intrusive or investigating in a way that we don't need to do that. So clearly that would be a concern. Probably similar to earlier comments, if there are any individual cases that need to be highlighted, we're happy to do that. I think perhaps part of the difficulty is that we need to take allegations at face value. There's an onus on us to do a certain amount of investigation to a point where we're happy that actually there's no offence or the counter allegation is not substantiated. So it's probably just trying to find the appropriate victim focused mindset of officers who are making sure they're doing their investigations in a timely manner, and equally are closing those investigations off at an appropriate stage before they actually press on. And the trauma-informed approach, again, is something we're simply trying to instill within officers. It's being discussed there at various conferences, and it's part of our training module that clearly officers, when they go out, must be victim-focused. And if they do that, and if they can progress and close off investigations, then I agree completely. Clearly, then they have more time to concentrate on other investigations and other aspects of victim support.
Thank you.
Okay.
And okay. So, and just in terms of look, I think and that's perfectly answered. I do think that trauma-informed policing. I think the face-fronting police who are coming into the home of the victim absolutely do need to be trauma-informed, and I do think that there is an emphasis and fairness around that. But I do think that there is still a lack of understanding of patterns of behaviour, and I talk about it a lot because I do think there's such a lack of understanding in that case, in terms of where systems are being used against the victim time and again. A system that is there to protect the victim is being used actually as a form of control. And there is times where you're seeing victims coming forward who are they're saying that there's coercive control within the relationship, or certainly was within the relationship, and that's not being recognised. And what's actually what police try to do is identify things like sexual assaults and all of those things, because they're easily identified, not recognising the pattern of behaviour, and that causes massive delays then waiting for a recommendation to be perhaps put on to the PPS and for them then to make a decision whether to take it on or not. And I think what I want is that the victims are supported in this, and that if we identify that early, it creates a system where there's no delays further down the road.
Okay. Point well made. Aoife, did anybody, you happy enough?
Just to say, fully agree with all of that, 100%, yeah. Okay,
folks, we are really struggling for time, so thank you very much for your attendance. It was a bumper session there, and thank you very much for the quality information you handed over, so thank you. Okay, folks, agenda item number 6 then is Justice Bill Committee Deliberations, Department of Justice Oral Evidence. Can I refer members to pages 397 of the meeting pack, which is a very good memo from the committee clerk on this next session. Can I inform members that the following department officials are in attendance to discuss a matter of issues relating to part 2 of the bill? Okay, this is the children part.
Excuse, Chair.
Yep, no problem.
Chair, thank you.
No problem. So just to remind members again, page 397 of the meeting pack. If I can just remind members that at the meeting on the 29th of January, members considered part 2 of the bill and expressed some concerns in relation to the matters set out in paragraph 2 of the clerk's memo. The committee also agreed to write to the department to advise it was actively considering a number of potential amendments in respect of part 2 of the bill. That included the addition of vulnerabilities to the relevant parts of clause 4 and the review of mechanisms to monitor the new youth custody and supervision orders. I would like to welcome to the committee Dr. Veronica Holland, Deputy Director of Rehabilitation and Reducing Offending Division, Jenny McIllarney, Policy Official Reducing Offending Division, and Andrew Laverty, Bill Manager, Department of Justice. Your second stint in a row, Andrew.
Yes.
You're a glutton for punishment. So can I inform members that they may also wish to refer to item 7.3 at page 410 of the meeting pack at this stage, which contains a briefing paper by the Department of Health on part 2 of the Justice Bill. So without further ado, if I give you an opening statement, or you want to get straight into questions?
No, we were just going to let you go straight into questions.
Right, okay. Thank you very much for that. I really appreciate that. You know how much I appreciate that. So part 2 then of the bill. Can I just add then, you would have heard our commentary and debate about the vulnerability section in relevant parts of clause 4. How do you see that with regards to the vulnerabilities of children and also the best interests of the child aspect of the bill?
I suppose in terms of the use of that phrase vulnerability, we would probably be of the view that we think that would likely be captured by needs, that it's not necessarily, I suppose, an additional provision that's needed. But I suppose in terms of that were to be included, I don't think we would have any material concerns in relation to it. You know, obviously from a committee perspective, you're coming at that in relation to kind of, I suppose, visibly strengthening the provisions as such. And I suppose in terms of those provisions more generally, in terms of, you know, what that would look like operationally, it's, you know, the provisions more generally are being considered in terms of having to have regard to. So, you know, I think our sense is in terms of that being included, it wouldn't necessarily create difficulties, but it wouldn't necessarily be something that we as a department would be including, but we don't see it as problematic.
On the specific aspects of the clause and the text within the bill, clause 4 talks about the juvenile's age, maturity and needs. Again, you might have been asked this before, but how do you measure maturity? How does a custody officer measure maturity?
I suppose in relation to those provisions as they're set out, it's obviously having regard to those provisions in terms of the information that's available to the officer. We would be of the view that this, I suppose, is putting in statute something that officers already do on a day and daily basis. You know, so it is looking at it from the perspective of what appears apparent to the officer from the information that's at hand. It isn't looking at it in the context of them undertaking any type of detailed assessment in relation to that individual. You know, we would view it very much as this is reflecting what officers will do on a day and daily basis. And, you know, those things that are apparent to them in terms of their engagement with those individuals.
Given what you've just said there, what about the word vulnerabilities within that? So the custody officer would take consideration of the juvenile's age, maturity, needs and vulnerabilities. Is that something you'd be open to with regards to an amendment?
As I say, I suppose from a departmental perspective, we think that vulnerability would likely be captured under the needs aspect. We wouldn't have, you know, it's not that we would have any objections in terms of that being brought within the scope of the provisions. I suppose we probably just would be of the view that it's not necessarily needed.
Okay, one other question from me then is, well, of two more. The youth custody and supervision orders on page 25. You put in an age of 14. So it appears to the court that the child was aged 14 or over when the offence was committed. This is regards to the youth custody and supervision orders. This article, the new 38A, this article applies where a child is found guilty by or before any court offence of, and, it appears to the court that the child is aged 14. Why is it 14?
In the context of that, and Jenny, you will keep me right in relation to this, the provisions that are in place in relation to orders for those that are 10 to 13 were never commenced.
No, so that's in the custody care orders. But no, in relation to this, there was a consultation carried out back in 2014 in relation to the development of a new order. And the responses to that consultation were very much in favour of restricting the new order to people aged 14 or over. And that kind of reflects what happens in practice currently. I mean, in the last 5 years, only one child under the age of 14 has been sentenced to a juvenile justice order, central order. So they're very rarely handed down. And our view would very much be that if a child is under 14 and if they commit a minor enough offence that it wouldn't attract one of the bigger sort of custodial sentences, then they should be sentenced to a community order, really, and they shouldn't really be in custody. So that's why the new order will apply to those aged 14 and above. So
it's more age specific rather than the criminal age of responsibility?
Yeah, it's just in relation to custodial orders for minor offences, really.
Right. Okay.
Yeah.
Would you have any offence, if you like, if that was changed, 14 was took out and age of criminal responsibility was put in there.
If it was just, I'm not sure in the existing juvenile justice centre order there is an age specific. It does say, because it would be assumed that it would be, I think. But the department would very much support the fact, that it is 14. It would be our position that a child under 14 shouldn't be sentenced to custody for fairly minor offences, because the evidence shows that the younger you're introduced into a custodial environment, the more likely you are then to reoffend and to end up, in custody as a young adult and a later teenager.
And
so it would be our position.
That's reflecting, I suppose, the thrust of the provisions in the bill more generally in relation to trying to ensure that those youngest children, in terms of their engagement with the system, that they're not drawn into the criminal justice system any earlier than they need to be, and that there's more, I suppose, more appropriate and child responsive ways in which to deal with the behaviours.
So explain to me again, youth custody and supervision orders, what are they intended to do?
Yeah, so they would be the most common order. They will become the most common order handed down to juveniles. So most juveniles really at the minute would get a juvenile justice centre order, but we're doing away with those because in order to ensure that children under 18 are never sent to an adult facility, we had to because most of our orders then were age specific, because we have the juvenile justice centre order and we also have an order in a young offender centre. So we had to do away with both those really in order to, just for the legislation, in order to prevent children from under 18 being sentenced to an adult facility, and the easiest way to do that was to create a new order. So in creating the new order, which very much mirrors a juvenile justice centre order, we made a few changes based on the consultation responses.
What happens to, if this goes through, what happens to a child aged 13?
Yeah, so if a child is aged 13 and commits an offence, and it's not a serious enough offence to attract one of the bigger custodial sentences, such as an offence under Article 45 of the Criminal Justice Order, or 13 or 14 under the Criminal Justice Act, the 2008 order, then they would be sentenced to a community order.
But now,
instead of going into custody, yes.
Yeah, so they would get a community order, but now at 14 and over would get a youth custody and supervision order.
They wouldn't necessarily, but they could still get a community order, but there would be that option of having a custodial order, whereas that option would be removed for an under 14.
Right, okay.
I suppose again it's also tying in with that more general, thrust in terms of it's not that in any shape or form we're saying that the behaviours wouldn't be dealt with, but I suppose just trying to ensure that it's dealt with in the most appropriate fashion, that if there's community provisions that, and it's appropriate that they're used for those younger children. And again, I suppose just trying to ensure that there's a range of options available for the criminal justice system in terms of how those individuals are dealt with, depending on the nature of the behaviour.
Okay. Emma, Deputy Chairperson?
You've covered it there. I wanted to ask around the vulnerabilities, and you've covered it.
Okay, Brian?
Okay. To ask about Clause 8, this issue of custody officer and when they can and could not release a juvenile on bail if they don't have adequate or suitable accommodation. So we've been told that this is not going to be introduced at this time. So it can just clarify what is the department's position. Will this clause remain in the bill? But if it's not going to be introduced? What would have to happen for it to be enacted?
I suppose in terms of that provision and its introduction, one of the issues is in terms of trying to ensure that there is suitable accommodation available for these individuals. I suppose in terms of that clause, the intention is that the commencement of that will be introduced at a later date. We were keen to ensure that the provisions remained in the bill, that we didn't have to wait and look at introduction of that in the next mandate, which could potentially be kind of a further 4 or 5 years away. I suppose in terms of the accommodation aspect, there are ongoing discussions with health in relation to that at the moment. Ultimately, the provision of that accommodation is the responsibility of the health trusts. We've previously indicated to the committee in terms of some of the other options that are in place and that are being looked at. There's a bail fostering scheme that is in operation at the moment that has been mainstreamed in terms of the Southern Trust. We have ongoing engagement and discussions with the health trust in terms of the potential for that to be rolled out to other areas. We're meeting with them next week in relation to that aspect. So I suppose we're conscious that there are a number of conversations and discussions to be undertaken in order that that provision can be commenced. But what we didn't want was to lose that provision and have, potentially have to wait a further number of years before that can be brought forward. Jenny, anything that you want to add?
So, would it be at the discretion of the department of the minister to introduce it, or would it have to come back to the assembly? Would it be?
No, that would be done by way of a commencement order in due course. But obviously, as part of that process, we would be engaging with the committee, advising in terms of what has been undertaken that would enable that provision to be commenced. What the processes and provisions in relation to that look like, what engagement there has been with health. So the committee would be very much, I suppose, part of any future stages in relation to that, but it wouldn't need to come before the floor of the assembly, if that makes sense.
It would? Or
no,
wouldn't?
it wouldn't.
Wouldn't? So it's not a...
It would be a commencement order just that would be needed, so the secondary legislation would be relatively straightforward, but as I say, we obviously would want to engage the committee on that matter before that would be introduced.
Okay, and I think we probably discussed this before, but the concern was a custody officer acting in good faith, concerned for a child's well-being, say if the bail comes through late at night, in the middle of the night, and is concerned for the child's welfare, but the juvenile is insisting, or their legal representatives insisting that they must be released. So by saying that the custody officer must not refuse to release a juvenile on bail solely because the juvenile does not have suitable or adequate accommodation, in good conscience they don't want to release a child onto the street late at night or in the middle of the night, but they could be in a position where they are committing an offence, just so there's still a sufficient cover for a common sense approach.
And I suppose in relation to that provision in any future commencement of that and the provision going live, we would obviously want to ensure that as part of that process that there was the necessary provision in place to ensure that there was accommodation. There were a range of options in terms of accommodation for that child
at a statutory level.
Yeah. And as I say, that that aspect of it is very much the responsibility of the Department of Health and the health trusts.
Yeah, it does say the custody officer may consider the juvenile's accommodation needs. Okay, that was just a concern we discussed before, that it doesn't make, there's some discretion for practicality, Okay.
Okay, Emma, you want to back in?
Sorry.
No, you're okay.
I'm going back here. We had talked about potentially bringing forward adding a new clause into the face of the bill to say that all actions must take the best interests of the child into account. I don't know if that's covered.
I think that was an issue that we touched on.
Yes, we had wanted that as well included when we had started drafting the instructions to council, but then OLC advised us that because there's already an overarching principle around the best interests of the child must be taken into consideration in any dealings around youth justice, or all youth justice organisations must take that into account. That's an overarching principle which cuts across the whole of youth justice already, so their view is that you shouldn't really replicate legislation that's already in another piece of legislation that covers it already.
Okay, and then just as well then, and it's further down, apologies, I thought we were still earlier, the clause that Brian was touching on there around a lack of appropriate accommodation.
Oh, is it?
Mm-hmm. Yeah.
It's 23.
There's no there's no resource for that in terms of what the amendment that we were talking about around ensuring that that a child can't be denied bail because of a lack of accommodation. So we don't know. I suppose Are
you thinking in terms of what the timing of that may be and when we may be in a position to bring that forward and what would be needed in order to facilitate that? And I suppose again, because you know, Health and the Trust is the lead in relation to this and has a statutory responsibility in relation to the provision of that accommodation. It will in part at least be driven by their ability to bring forward changes in relation to that. As I say, there are a number of aspects that are being looked at the moment. You know, the bail fostering scheme has started to be brought forward. It isn't really, I suppose, feasible or certainly not at this point in terms of having you know, a single facility that would be able to deal with children that may need that accommodation, just because of the sheer numbers that would be involved would be quite small, and also that dispersal across Northern Ireland. But it is something that we continue to have discussions with Health in relation to how best we can try and get that progressed so that we could reach a point at which the provisions could be commenced.
Okay, so we're sort of in no man's land with that at the minute, I suppose. It's a practicalities issue, so there's no point in bringing an amendment if it's not going to be realised.
I suppose we'd pose the question, would you think if we put a time scale on commencement, would that be unfair on the department?
From a departmental perspective, I think because there are limitations to how much we can move this forward. You know, we will obviously continue to have those discussions and engagement with colleagues in the Department of Health, but ultimately it will be, the solution will largely rest there in terms of enabling us to commence that. And I think it's something that probably certainly would be outside the gift of Department of Justice officials in order to deliver that if there were a time-bound period put in. The difficulty is then that we would technically could end up in breach of legislation if it, say for argument's sake, a time frame were put in that had to be commenced within a 12, 18, 24 month period, whatever it may be. We may not necessarily be able to deliver on that.
Blue sky thinking here, but regarding the letter we received in the Health Committee around the new Regional Children and Family Services Authority, would it be in order, do you think, that we would put a duty in the bill that would be their first aim and objective?
And I suppose, Jenny, certainly from the conversations that we were having earlier, I suppose while they're connected, they're two separate aspects in terms of one is that agency authority being set up, the other is the accommodation issue and what was touched on at one point in terms of kind of a single location or a single campus that may provide for something like this. I don't think that the two necessarily totally go hand in hand, and I think it would probably still come up against the same issues in terms of how quickly the Health Trust and authorities were able to move in relation to that.
Okay, Emma?
Just the last one then, the threat to public order, and I suppose it refers both to the child themselves and to the community. Will the department be issuing guidance around how that's going to work in practice, or who, we've had conversations before about making that judgment call?
And I suppose as part of the police, as part of their deliberations more generally, and the applicability of those provisions to the child will take account of both, and as you say, it is coming from both perspectives. There's a potential in terms of the response of the community, or the potential in terms of what the action of the child may involve in relation to that. Again, it's something that police will be considered. It will be part of kind of police deliberations and considerations, more generally, and also in terms of how that individual child is going to be dealt with.
Yeah,
Jenny,
I would just say yes. I mean, obviously that provision applies to courts as well as police, and for police it's only in relation to bail conditions, not in whether or not they can deny a person bail. So it's not as serious, obviously, in relation to police.
At the police stage.
But also at courts obviously have to make, first of all, there are two tests. So the first test will obviously be whether or not the offence meets the threshold for a custodial sentence anyway, and if it doesn't, then the child will have to be released whether or not there's that threat to public order. And secondly, then obviously they have to take that into consideration as to whether that threat can be managed in the community with other conditions put in place. So the guidance we're developing to go alongside the legislation will obviously clearly set that out, and will emphasise the fact that even if conditions are put in place around that fourth provision around bail, that it should only be for as long as that threat actually exists, and will have to be removed then and reviewed as well. So
our sense would be that those provisions would probably, it's likely that it would be fairly limited circumstances in which those provisions would kick in. Mm-hmm. As you say, Jenny, because you've the other kind of hurdles or tests to meet before you would kind of reach that position where that would be being considered.
Okay, is that you, Emma?
Yeah, thank you.
Can I just ask you then, on page 22 you have the record of decisions concerning bail when the judge refuses to release a child. There is a duty in there that if the child requests it, they can get a copy of the record as to why they weren't released. How would a child know? And should we...
To be honest, we were hoping that they shouldn't really need that, because obviously the child will be in court and will hear, and the solicitor then will obviously be explaining to the child, you know, why they haven't been. If they haven't, they'll have a solicitor who'll explain that to them. I suppose it's just an extra measure that if somebody would want it, then it would be made available to them. But I mean, they'll be fully aware from listening to the argument. The judge will always set out clearly why bail has been refused, and the solicitor will be there on hand as well to explain that. And if they do go to custody, then the YJA staff will also be speaking to them straight away about bail, why they've been refused bail, what they can do in order to try at the next bail hearing to ensure that they can get bail.
Well, I understand that bit, because that would be the court setting and the judge would be laying that out, and the child would be hearing it, whether he understands it or she understands it, and the solicitor and the barrister is there to represent and advise. But the provision is that the child, if the child requests it, they can get a copy of
the bail decision.
The bail decision. So how will a child know that they can actually get a copy of?
Well, I mean, suppose we haven't really discussed that. The child's solicitor could obviously make them aware of the fact that they, you know, that they're entitled to it if they want it.
It would likely
be
through
very
the legal
rarely be needed,
representative.
but yeah.
Yeah.
And obviously any discussions that were being held either with the children's parents or any guardian in relation to that individual would probably be a combination of you know, through the legal representative, or any conversations that those in a caring capacity would be having with that person.
I mean, the guidance we're issuing will obviously, you know, will cover all the clauses, and it'll be sent to all the relevant agencies as well, such as Youth Justice Agency, and everybody will have a copy of that, so anybody who's engaging with a child in that kind of capacity will be aware of that and will be able to advise them.
I suppose it begs the question, what advantage does it give to the child to have a copy of the reasons why he was refused bail?
I think it was just through maybe the bail report, it said the children should be, you know, and through obviously UNCRC recommendations say the children obviously should be involved in decisions that are relevant to them, and they should be made aware of any information that is, and they should be entitled to receive information around their own cases. So it was really just put that in statute and to sort of...
Okay.
You know.
Just one other question for me is, how would you feel about an amendment on the a review mechanism on the use of the youth custody and supervision orders?
You would have no objections to that?
No, and I think it's probably similar, you know, on different and other pieces of legislation where, you know, the department would typically do something like this as part and parcel of kind of the policy making process. You know, it's something that would be undertaken in any event. We would probably be of the view that it isn't necessary to have it included on a statutory fitting, but we wouldn't have any objections to it.
What sort of timescale would be fair in your eyes?
I think 3 years is fair enough. Yeah.
I mean, that would certainly be consistent with similar mechanisms in the Protection from Stalking Act and the Domestic Abuse Coercive Control, where I think certainly the Stalking Act, it's clause 20, and it's no sooner than 2 years from the point of introduction and no later than 3 years for the first report, and then 3 years subsequent up to a maximum of 10 years. I think there's a sunset clause or a sunset provision that after 10 years it can be curtailed, that reporting requirement. So,
okay, thank you very much. No other questions. Is there anything you want to add or put to us when you've heard our deliberations over the last number of weeks? That's maybe scary. That's maybe a bad question I've asked you there.
I have nothing new.
No, nothing from my perspective.
Well, we'll still of course engage through the written form and see if we can come to some sort of... Would you consider putting in the amendments with regards to review of the order?
Certainly take the Minister's views on it, and I don't think that OLC colleagues would consider it something that's beyond their capacity, because they were largely responsible for certainly the Stalking Act review mechanism. I think what would shape the content of the review mechanism is the information that you would want to have available. And our concern with the Stalking mechanism was that a lot of information was requested that was never going to be readily available without significant additional cost and new IT systems. So it's about managing expectations around what's useful for the committee's review and purposes, but also making sure that the reporting requirement doesn't become overly onerous on the organisations that are operating it.
And I suppose there's probably also the issue of whether or not the committee at this stage has a sense as to what they would want any amendment to look like. Would it simply be that a review is undertaken in 3 years, 5 years, or whatever the time frame may be, or would there be anything additional that would be wanted?
Well, what we'll do to make it clear is we'll write it formally, just so that it's fair on you guys, and the points taken with regards to the actual information that would be required on that review, and not to make it onerous on the department or unrealistic with regards to.
Well, it's operational colleagues that most of the responsibility falls upon when you're talking about charges and convictions and sentences of detention and whatnot. So but with the Causeway system, there's a lot of information out there, but it's about where
where you go and find
someone perhaps has a particular idea about something that they have a personal interest in, and it not necessarily being something that's readily available.
Okay. Well, thank you very much for your time.
Thank you
very much.
It.
Okay. Somewhere in this, we're putting the discussions that we had today onto.
Yeah, we could
do it now.
Yeah, if you want to.
Is it be anywhere in the pack?
No, it's not. I don't remember.
Okay, folks. So I think what we need to put on record is the deliberations, the informal deliberations we had today around some of the issues. Pick up if I have left something out, because I took scant notes. But basically on the biometrics part, we did the amendments. We did show some concern about the right of request to a police station to obtain biometrics, and then of course that led on to the discussion around taking of biometrics for fixed penalty notices and out of court disposals. We also talked about the vagrancy piece and the fact now there's question marks around whether this will be going forward as a ministerial amendment, and where does that leave the committee with regards to deliberations, with regards the repeal of the vagrancy laws, the two of them, and then what gaps would have been created with the repeal of those laws. So we are very much in a bit of a limbo state there with regards to our destiny's not our own, and we have to wait and see just if the Minister can move her amendment on repeal of vagrancy laws. There was an issue on the live links part and whether we would look or seek for an amendment on a review of the operation of live links, and then that would mean that the committee would have to be very sure of what it actually wants to see in any review, similar to the discussion we had there with the officials around the orders. Is there anything else anybody thinks I've missed out there with regards to our earlier discussions, or are you content that has been placed on record?
Happy enough.
Clark, you happy enough? Yeah, you're happy.
You captured everything.
Okay. So can I advise members then, it would be helpful if the committee could reach a position on whether it wishes to make any amendments at this part of the bill and actually solidify our thoughts on the amendments. So if it would be in order, we could go into closed session for a very short period if you think that is needed, or we can just invite proposals from members with regards to the amendments that we think we are confident in going forward on. It really is up to yourselves. So we've looked at a review of the orders, we've looked at the review of the live links, we've looked at we need to ask questions more around the biometrics and the DNA collection with regards to going to the station. We'll probably write more on that, but it's whether members feel more comfortable going in a closed session to talk about these things, or whether you're content with the two reviews that I mentioned. Also the vulnerability, adding to the bail condition part for the custody sergeant. Are members content with that one? To add in then the vulnerability alongside the maturity, age and needs.
Yep.
I'm thinking off the top of my head here, what else have we sort of discussed with regards way of amendments?
Chair, sorry, those are the ones from today.
Two-year review.
Say again?
2-year review.
Yeah, or the 3-year review was what they had sort of.
They've said 3 throughout the second part there, but
Yeah.
had we not decided in 2 years because it's already implemented?
Yeah.
I think, Chair, what might be helpful to do, I know it mentioned earlier on, to maybe ask members, for their views on what will be looked at in those reviews.
Yes.
And to help that, what we could do is to extract the clauses that Andrew mentioned from the Stalking Protection from Stalking Act and the Domestic Abuse and Civil Proceedings, I think it became actually, Act. And we could circulate those in the email to members, so it gives you an idea of what those things look like. And then there's, as the Chair said, added vulnerabilities. The other things that obviously members have highlighted, I think, in recent discussions is the issue of photographs is a big one. And the potential to look at some of the review periods for some of the lower, smaller review periods, 2 and 3 years for biometrics.
Does anyone have a comment around the amendment for photographs and the biometrics piece? Or do you want to wait to go in a closed session, or do you want to?
I think we've rehearsed it.
Yeah.
Like we all believe the photographs should be included. They're saying they don't have the policy, so.
Yeah. So we can write to the department that the intention is that we're actively looking at an amendment on photographs.
Or even I think what do you call the word? Not capability.
An order making power.
An enabling power.
Enabling power, yeah.
Enabling power to add photographs at a later stage. I think those are the two options. Yeah, members.
So is the committee wishing to write to ask the minister whether she would be content to bring forward first of all either of those two options, and depending on the response, then if the committee needs to take it forward, then it could consider it after that.
Are members content to proceed in that way? Are there any other amendments that we have discussed that I have forgotten about? I don't know that there is. But that's enough. There's plenty of work there to go on with regards to communicating with the Minister.
So at this stage, just to clarify, is the committee agreed to write to the Minister on the potential photographs amendment to Part 1 of the bill, and to add in vulnerabilities at the appropriate points in Part 2?
Yep.
And then the reviews will manage separately, because we need to look at a little bit more in that.
Okay. Members content?
Yeah.
Okay.
Is there anything else before we move on?
There's still some parts of the bill to go
yes,
through.
And we still some of the amendments to go through informally. Yes, absolutely.
I think maybe, Chair, at the start we've 2 sessions on next week, but it might be worth taking an hour right at the start to do closed session to try and get through as much more as the committee can before we go into the budget session and then the out of court disposals.
Okay. We're moving on in an hour, let's hope. Agenda item number 7 then is Justice Bill written papers. Can I refer members to page 400, Department of Justice further amendments to the Justice Bill, barred and advisory lists and former officers' misconduct proceedings. This contains a paper from the Department of Justice providing an update to that targeted stakeholder consultation exercise in respect of the review of the police officer misconduct procedures. Drafting instructions relating to the creation of a barred and advisory list have been submitted to the Office of Legislative Counsel, and the Department expects to receive the draft clauses in the coming weeks, which will be shared with the committee. This is something we have asked for. With regard to the other matters which will be taken forward by delegated legislation, the Department has advised that the outcome of the police misconduct matters consultation will be shared with the committee along with the draft regulations, so that the committee may consider these together. So can I seek members' agreement to request an oral briefing from departmental officials on the proposals for delegated legislation on these matters at the appropriate time? Agreed? Okay, 7.2, Department of Justice Independent Custody Visitors, ICVs, amendment intention. Can I refer members to pages 404 to 405 of the meeting pack? Can I inform members that the Department of Justice has provided the committee with an update on the operation of the Independent Custody Visiting Scheme, specifically in relation to issues identified regarding access to independent custody visitors to custody records. The update advises that the committee advises the committee that it is the Minister's intention to bring forward an amendment to the Justice Bill in relation to ICVS as the only legislative vehicle available to make this change within the mandate. The proposed amendment is aimed at addressing the identified gap in access to custody records, particularly in cases where detainees are not capable of providing consent for their custody record to be reviewed. The Department will provide a further update once the amendment has been formally tabled, but officials are available to provide members with any further briefing or information they may wish to have on the matter. So can I ask members if they are content to note the Department's paper?
Yeah.
At this stage? Okay, 7.3 Committee of Health Forward Department Health written paper. We have already alluded to this. Can I refer members to 410 of the pack, which contains a briefing paper from the Department of Health on Part 2 of the Justice Bill in relation to children, which was forwarded to the Committee for Health. The paper outlines some of the past and current cross-departmental work being undertaken by Health and Justice to support young people, including those who come into contact with the justice system in Northern Ireland. The paper advises of proposals for the Health and Justice Ministers to work together to identify and take necessary steps to establish a new regional children and families services authority, incorporating children's social care and youth justice services. So can I ask members, are you content to note the paper? 7.4 then is all the groupings with regards to the report. You can read them yourself. It's at page 421 of the meeting pack, which contains a joint briefing paper by the 10 is Too Young member organisations, which sets out a number of key asks in relation to Justice Bill. Can I ask members, are they content to note the paper at this stage? Okay. 7.5 then, the Christian Institute report. Does smoking contribute to negative outcomes for children? Refer members to page 425, which contains correspondence from the Christian Institute in relation to the defence of reasonable chastisement and the proposed removal of it. Members will be aware that the removal of the defence of reasonable chastisement is not a planned departmental amendment, but has been tabled by an individual MLA. So can I ask members if they're content to note the paper?
Yeah, I think, sorry, Chair, just to bring you back to 7.4, they offered to meet with us, or are we taking them up on that?
To meet as a committee. I know that they've been doing the rounds with regards to individual members of the committee. I met with them a number of weeks ago. It was quite useful. Morris maybe has met with them too.
Oh, right. Yep.
But
the committee heard from all of those organisations.
Yeah,
it's taken evidence formally from.
They're only too willing to meet with your party members.
Yeah.
On that. So 7.6 Minister of Health response to secure care accommodation. Can I remind members that at its meeting the 15th of January the committee agreed to ask the Department of Health if and how it has benchmarked the provision of secure care accommodation against other jurisdictions in the rest of the UK and the Republic of Ireland, and if those jurisdictions make use of other providers such as the community and voluntary sector. I think this was maybe Ciara had raised this. Can I inform members that the response from the Department of Health is contained at pages 474 of the pack? Can I ask members if they're content to note? Okay. Department of Justice, clause 28 of the Justice Bill. Can I refer members to pages 18 to 19 of the table pack for correspondence from the Department providing an update on developments with regards to taxation reform elements of the Justice Bill. As the committee had previously advised, a further amendment to the bill is being proposed to facilitate a revised approach to taxation reform which was being taken, which seeks to expedite reform by setting legal aid rates and arrangements for all proceeding types, which retaining the taxing master in an assessment role. The Department has advised that advice was sought on the impact of that proposed amendment on clause 28, and that as it does not relate to the current policy position of setting legal aid rates and arrangements for the taxing master to apply, it will be removed from the bill by way of amendment. Not sure how that works. The Department has undertaken to provide a more detailed written briefing as soon as possible. So basically what they're saying, if I am right, is that they're going to basically take out clause 28 altogether, and they did talk about putting something else in its place. Can I take members' views on whether, given the circumstances, it is necessary to hear from the department officials on taxation reform at this stage? I think we have to wait and see what they produce.
Yeah. I mean, is this relevant to the
bill?
Current strike action too? Is it
not really?
Are future arrangements going to be dependent on agreement, with the Bar Association?
I don't think that's part of the elements of the strike action, but
right.
The Minister wants to reform this piece with regards to taxation of legal aid. She did talk about the burden that was placed on our budget. So we'll have to just wait and see what comes forward.
Yeah,
So would the members be agreed that when that comes forward we can seek views from the department?
Yeah,
okay, agreed. Agenda item number 8 then is SL1, the Coronavirus Act 2020, extension of provisions relating to live links for courts and tribunals, Order Northern Ireland 2026. Now I refer members to page 477. Can I advise members that this is the committee's first proposal for a statute rule to be handled under the Assembly's new scrutiny procedures? Information on the new procedure is provided Appendix 1 to the Clerk's memo for ease of reference. Members are asked to formally agree a number of standard actions for the handling of this SL1 and all future SL1s in line with the new procedures. So can I seek members' agreement to the following actions for all SL1s in each case hereafter? That the committee issue a call for views on the proposed statutory rule using the standard survey, publishes the SL1, the draft copy of the proposed statute rule, and any relevant departmental documentation on the committee website. It publishes any responses received to the committee survey for each SL1 after they have been considered by the committee. And lastly, agrees that the committee staff may seek information from the department where necessary on any matters raised during consideration of any SL1, including any arising from a survey. All information provided by the department will be provided to the committee to inform its decision making on the proposal. So can I seek your agreement for those 4 elements? This is the new way we're doing SL1s, just like every other committee. Okay.
Great.
Can I advise members that having agreed these actions for the handling of all future SL1s, members will only be asked hereafter to note receipt of any SL1 and draft copy of the proposed statute rule, and that these will be published as part of the call for views on the proposal. So in relation then to SL1, the Coronavirus Act 2020, extension of provisions relating to live links for courts and tribunal, Order Northern Ireland 26, can I seek members' agreement to note the receipt of the SL1 and the draft copy of the proposed statute rule, and that these will be published as part of the call for views on the proposals? Agreed? Can I seek a members' agreement to consider the proposed statute rule SL1 at its meeting on the 5th of March 2026, subject to the needs of the committee and any further information of evidence? Agreed? Okay, thank you, members. Agenda item number 9 is correspondence. Can I inform members that there are a correspondence memo on 12 items of correspondence at page 505 to 614 of the pack, and 1 additional item at page 21 to 61 of the table pack. Can I members are reminded that the correspondence in the table pack is embargoed until tomorrow the 13th of February, 1 minute past midnight. Just be mindful of that, members. Can I advise members that I will draw their attention to 5 of the items of the meeting pack, and that members will then have the opportunity to comment on other items. Can I advise members that there is a slight error to some of the item numbering towards the end of correspondence memo, but members will refer to the item list on page 505 of the meeting pack for the correct items. So 9.2, can I refer members to page 509, which contains a response from the Department of Justice to the research by the Women's Research and Development Agency on the use of firearms and violence against women and girls. Can I inform members that the response highlights that the Justice Minister is meeting with the author of the research, as well as providing policy information on firearm licensing by the PSNI. Can I remind members that the committee had agreed to invite WRDA to present on this research at a future meeting? So can I seek members' agreement to forward the Department's response to WRDA? Yep. Agreed. 9.7 and 9.8. Can I remind members that at its meeting on the 15th of January, the committee considered correspondence from the Department on the Adult Protection Bill currently being considered by the Health Committee. The Department's correspondence indicated that some of the provisions in the bill impacted those operationally independent from the Department, and recommended the committee seeks the views of these organisations. Can I inform members that responses from the PPS and the Probation Board have been received and are available at items 9.7 and 9.8 respectively in the meeting pack? Responses from the PSNI, the Policing Board and the Belfast Harbour Police are still outstanding. So can I ask members if they are therefore content to forward both responses to the Committee of Health to inform their considerations on the bill? Agreed? Agreed. 9.9 and 9.10. Can I remind members that at its meeting on the 20th of January, the committee considered correspondence from an individual regarding the handling of Freedom of Information requests to the Northern Ireland Policing Board, and members agreed to write to the Policing Board to ask for an overview of their processes and procedures in handling FOI requests. Can I inform members that a response from the Policing Board is available at pages 5, 7, 6 of the meeting pack. The response outlines the Board's procedures, but acknowledges that it is dealing with a significantly high number of FOI and DPA requests, specifically in relation to the police pensions and injury benefits benefit branch of the board, and this has had a detrimental impact on their ability to meet statutory response deadlines for these types of requests. However, the board is working to clear the current backlog. Can I inform members that at its initial correspondence, the individual had requested that the committee seek clarification from the department on what oversight or assurance mechanisms exist in respect of FOIA compliance by arm's length bodies. However, this wasn't agreed by the committee when the correspondence was first considered. So can I seek agreement now to request this clarification from the Department of Justice? Agreed? Refer members then to page 579 of the meeting pack, which contains further correspondence from the same individual seeking the committee's assistance in accessing a copy of the guidance to medical practitioners on injury on duty awards. The individual has advised that they have been unable to locate the guidance on either the department's website or that of the policing board. So can I seek members' agreement to ask the Department of Justice and the policing board to clarify on where the guidance can be accessed? Agreed? Can I ask members if they're content to note other items of correspondence, or does anyone want to raise anything? No? Okay. Agenda item number 10, Forward Work Programme. Can I inform members that the latest draft of the committee's Forward Work Programme can be found at page 616 to 621 of the meeting pack? Can I ask members if they're content to note the Forward Work Programme? Agreed. Can I remind members that next week the committee is receiving oral evidence from departmental officials on the draft multi-year budget allocations? So agenda item number 11 is chairperson's business, of which I have none. Agenda item number 12, any other business?
Chair, the sentencing bill then is during the meeting here, it seems to have been announced by the department that it'll be brought forward. So
that's something to look forward to once we get finished the justice bill. Yeah, hey. Okay, agenda item number 13, date and time and place of next meeting. I say bring it on, Brian. Any legislation?
No, it's timely.
Yeah. Can I advise members that the next meeting will take place on Thursday 19th of February 2026 at... So, do you want to meet at 2 or do you want to go to 1:30?
Yeah, it's tight for me. Communities beforehand.
Yeah. Okay, so your preference would be 2. Is there any...
Not precious.
Is there any other...
I can do without a cup of tea.
Oh no, we'll get you a cup of tea. So we are really, because we're at the business end of the Justice Bill, so despite protestations from Morris, could I seek that we meet at 1:30? That'll give us a chance.
Who your friends are now.
It'll be tight, but I'm happy enough to start at 1:30. It'll just be tight with our committee.
Yeah.
I'm content, Paul.
Again, Doug?
I'm content, 1:30.
1:30. Okay, thank you very much, folks. So that's at room 30, Parliament Buildings. The meeting is adjourned.